Good morning, everyone. My name is Elena Bowers. I am a supervising attorney at Legal Aid, and so excited to see those of you in the room. Thank you for joining us in person. Thank you to Kroll for hosting us and all the work that you all have done in hosting us. Thank you to everyone who's joined online. I know we have a lot of people who have also joined in the webinar online, so thank you all. We're very excited for the enthusiasm that folks are bringing to the Right to Counsel relaunch. Excited to get you all trained up and start placing some of these cases with you all. As folks trickle in, of course, we will, continue to greet them, but just want to go ahead and get started so that we can get through our very packed training morning. For folks online, if you have questions, you can drop them in the Q&A portion. We will be answering questions at the end of each sort of substantive section. So, to get us started, welcome to the Housing Right to Counsel project. We are very, very excited to be restarting the project and bringing new energy into it in an effort to help some of our neighbors stay housed. With a quick introduction to the project, importantly, I assume that most of you are here because you already know a little bit about what the project entails, but the goal of the project is to place eviction matters for people who have subsidies with pro bono counsel at law firms, with the federal government, or with OAG, in order to increase the legal representation that tenants have in these cases. And the main goal of the project is to preserve subsidized housing. As we all know, the district is getting increasingly unaffordable, and for many of our low-income neighbors, the best and only way to remain housed in the district is to have a subsidy. And the best way to preserve these subsidies for people is to prevent them from getting evicted in the first place. A little bit about how the project works mechanically. We're sending letters to a subset of people who have cases filed against them who have subsidies, guaranteeing them representation. We're then taking those cases and sending them around to all of our law firm partners for someone to actually provide that representation. And each law firm and the federal government and OAG are partnered with one of the eviction defense providers for direct mentorship, so that you have access to someone who practices in this area of law daily, and so that you can ask questions that you have and ensure that you can provide high-level representation to tenants. There's also a bank of resources that's maintained on probono.net that you can utilize as a first reference. So, a little bit about our client population. We represent people, or this project represents people who are living at or below about 250% of federal poverty. In DC, 1 in 6 residents live in poverty, and that includes 1 in 4 children, so a lot of families. East of the Anacostia River, it's 1 in 3 residents living in poverty, which is half of whom live in deep poverty. Now, when you are approaching these cases and meeting your client for the first time, consider your client's background and the challenges that they face. Likely, your client will have very little or no income. They may have no experience with lawyers, or at least no positive experience with lawyers. They may have health conditions or past trauma, and there are competing demands on their time, their energy, and their money, given the number of issues that our clients face all at the same time. So what we recommend is, when you're meeting a client for the first time, one of the important things to think about is how you're going to counsel the client and how you're going to develop trust with the client. And we recommend taking a client-centered approach, which is empowering your client in the process that they're experiencing, showing empathy and respect for what they're going through. And your representation might require very, very difficult conversations with your clients, talking about intimate things that have happened, or allegations against them that are frankly offensive. Sometimes it's about unreported income, or sometimes our clients are embarrassed to tell us, I just couldn't afford it. I just don't have enough money. And so it's really important to work to build trust with your client before you're having these conversations, and to, continue to think about what value you're putting and what judgments that you might be making or they might think you might be making. So the three main programs that we focus on providing representation for, there are three main types of subsidized housing in the district: public housing, site-based Project 8, or site-based Section 8, or project-based housing, and the Housing Choice Voucher Program. And we'll get into more detail about each of these programs a little bit later. So public housing is publicly owned by the District Housing Authority, and they typically own and manage it. So it'll be cases where DCHA, or the DC Housing Authority, is the plaintiff. Some have private managers, but for the most part, it's DCHA. There are also private managers sometimes at redeveloped sites. This is mostly for you to think about when you're trying to identify the subsidy that your client has. DCHA is funded largely by HUD. They receive large annual payments. They're governed by both federal and local regulations, so you'll be looking at both and thinking about the statutory framework that you're thinking about, or regulatory framework. They have a standard lease. You can't really move them from unit to unit easily, except in emergencies. And people who live in public housing recertify with a DCHA manager on site. Site-based Section 8 is a private landlord owning a building which has subsidies in it that are tied to individual units. So they have a certain contract rent amount. They pay income based on their rent amount. They pay rent based on their income. Site-based Section 8 is governed by federal regulations only. There are no DC regulations. Again, they're not really portable. Sometimes you can transfer within the same property, but there's no right to transfer out of that property unless there are instances of domestic violence, but it's very, very challenging. And again, you recertify on site with the property manager. And probably the most common that we'll be seeing at the beginning anyway are people who have housing choice vouchers or Section 8 vouchers, where a tenant gets a voucher, places it with a private landlord, and DCHA, the voucher program, helps pay for their market rate rent with a private landlord. They are administered as a public benefit program by DCHA. There are federal regulations governing the process. They are portable. They can be moved throughout the district. They can be ported outside of the district. And they recertify at the main DCHA building. There are many obstacles to voucher utilization in the district. It's very challenging. And we can go into more of that later. So when you're taking a case for the first time, it's really important to figure out which type of subsidy your client has in order to figure out what their defenses might be, what their options are. And so this slide is helpful for reference and thinking that through when you're meeting with your client. If the landlord or the plaintiff is DCHA, it's going to be public housing. If it's a private landlord, it could either be site-based Section 8 or the voucher program. And then the next question that's helpful to ask is, where does your client recertify? If they recertify at the rental office, it's site-based Section 8. If they recertify at DCHA, it's the voucher program. Recertification. One thing that you will hear often with your clients is that they recertify. And the process of recertifying is the process of reporting their income to whatever subsidy provider that they have, and reporting the people who live in the household and the income of other people in the household. And that's so that their rent can be properly calculated so that it's affordable to them. Most subsidies, rent is calculated at 30% of someone's income, which is what is deemed affordable. Most of our clients will recertify on a regular basis, either every year or every 2 years. It's important to note there are also rules around interim recertifications if there's an increase or decrease in someone's income. Failing to recertify or failing to provide all of the documentation can be a violation of the program rules. And so sometimes we are seeing clients for eviction because of that failure to recertify. So interim recertifications is when someone loses a job or a child who's employed and contributing to their income moves out. And it's very important for our clients to report this right away so that their rent can be properly calculated and they're not liable for rent that they can't afford. Whether or not they need to report an increase in income depends on the program, so it's important to know what program that they have and look at the specifics, or talk to your mentor. Another way to figure out what type of program it is whether the subsidy is tied to the unit or whether the subsidy is portable, or someone says that they placed it somewhere or they can move it. If it's portable, then it's going to be a voucher. If it's tied to the unit, it's public housing or site-based Section 8. And then I think lastly, the last question to help you figure out which subsidy it is whether they have a relationship with DCHA. And if you're having issues at the beginning figuring out what type of subsidy it is, it's very important to talk to your mentor in order to dive into some of this. Before we move on to the next section, are there any questions from the room or from the internet? Hearing none, I'd like to welcome my colleague, Adam Marshall from Neighborhood Legal Services.
Hi, everyone. My name is Adam Marshall. Like Elena said, I am the managing attorney at Neighborhood Legal Services. And I will be joining Elena for this next section, where we'll talk about some of the substantive law that governs evictions in DC.
You want me to click while you're talking?
Sure. So the majority of cases in DC, the vast majority, fall into two categories: non-payment of rent and lease violations or notice to quit. And non-payment of rent is within that the vast majority of those cases. Well over 90% of eviction cases in DC are non-payment of rent cases. The lease violation case is the second most common type of case. You'll also hear them referred to as 1A and 1B because the complaint form for non-payment of rent is Form 1A, and the complaint form for lease violation is Form 1B, and the complaint form for both of them is 1C. So DC is, as some of you all have probably heard, a for-cause or just cause jurisdiction. That is to say that there is no eviction in DC simply because a lease expires. A landlord in DC can only sue to evict a tenant for the limited enumerated reasons that are laid out in DC Code 423505.01, also known as the Rental Housing Act. And so once a lease does expire in DC, it will automatically revert to a month-to-month tenancy, generally with the same lease terms. So there's no option to terminate, there's no option to evict a tenant. If a landlord wants to evict a tenant, there needs to be an enumerated reason found in the Rental Housing Act. Self-help evictions are also illegal in DC. Landlords cannot just simply change the locks or remove belongings. They need to use the landlord and tenant court process, obtain a judgment, and get the marshal service to carry out the eviction. Yeah. Or not.
No, go ahead.
Yeah.
Sorry.
For non-payment of rent cases, we'll go over the statutory elements that a landlord needs to prove. And then Elena will talk about the defenses to those elements once a landlord proves its prima facie case. So in order to prosecute a case for non-payment of rent, the landlord needs to prove the existence of a landlord-tenant relationship. This is usually done through a lease, but and there will almost always be a lease in cases with subsidies because that's one of the program requirements. A landlord also needs to prove that a legally sufficient notice was served, and we'll go more into notices and the technical requirements later in the presentation. They need to prove that that notice expired, and that notice requirement, there used to be a way to waive it if a lease provision had a waiver of that notice. That was never applicable in public housing, but now new or couple-year-old council legislation makes that waiver provision illegal, so that notice is not waivable. Finally, in order to meet their prima facie case, a landlord needs to allege and prove that rent is owed. This is usually done through a rental ledger, and if you go to trial, the assistant property manager or whoever will get that in. And there is also a new, or again, couple-year-old requirement that in order to take a tenant to court, a tenant must owe at least $600. So it used to be the case that there were a lot of cases that were filed for very small rental debts. Landlords had very quick triggers, and it was essentially a debt collection tactic. But the council raised the threshold in order to cut down on the filings for amounts under $600.
And one of the interesting things about this is before this was enacted, we would often see suits in subsidized housing cases for $20, $25, which are just, a horrifying waste of time and way of harassing tenants. So really important protection that was enacted during the pandemic. So many of our clients will come in with non-payment of rent cases because they have not paid rent. Whatever the reason that they have not paid rent, they can't afford it, they had to pay for some other expenses. There are defenses that you can raise to help fight the balance or lower the balance. The main defense that we see, especially in public housing, but many other forms of subsidized housing, is what's called the breach of the warranty of habitability. And that's just the conditions in the unit are bad. There's an implied warrant of habitability in every lease in the District of Columbia, and there's case law on that. And the elements that you have to prove in order to say they violated this implied warranty of habitability is that there were conditions that that violated or that constituted a violation of the housing code or the property maintenance code. You need to prove when those conditions were in existence, that the landlord knew or reasonably should have known about the condition, and that the landlord failed to repair the condition within a reasonable time. You also need to show that the condition affected the tenant's use and enjoyment of the property, which is easy enough when we're talking about a leak or heat that doesn't work or a mouse infestation. And the tenant has the burden of proving the extent by which the value of the premises was reduced by the conditions. Another one that can be used but is much, much, much less frequent is a void lease, and that can ask that the court can declare the lease void and confer no benefit to the landlord. I'm going to brush past this one because I think it's unlikely that you guys are going to use it in subsidized housing cases, but it's here for reference if that is useful. And then another one that we see very frequently is retaliation. Tenants are protected from are statutorily protected from retaliation. And so what that would entail is claiming that the suit is brought in retaliation to punish them for an assertion of their legally protected rights. So asking for repairs, complaining about harassment on the property, any of these things. And the statute and regulations refer to actions not otherwise permitted by law, but the DC Court of Appeals have interpreted that to include other lawful actions as well. And so regulations specify that retaliation involves a landlord acting with the intent to injure or get back at a tenant in response to a tenant's exercise of any right conferred upon the tenant by law. We don't have case law interpreting this yet, but it's still something that we use on a regular basis. There is a presumption that a landlord is retaliating against a tenant if the landlord acts or files suit within 6 months of a tenant exercising their rights. And then, it's a rebuttable presumption, so then it flips back to the landlord. It can be a complete defense even in non-payment of rent cases. Back to you.
All right. So constructive eviction, this is essentially almost a version of the implied warranty defense, except that in the case of constructive eviction, there is a complete collapse of the contractual consideration that the premises were originally leased for. The premises become, at some point, totally unfit for habitability. The roof collapses. There is no heat or electricity in the winter. There is a water intrusion that is bad enough that there is mold everywhere, and the tenant is not able to reside in the premises. And that then causes the tenant to vacate because of the poor conditions. And so for a period of time for which you are able to prove that the tenant was constructively evicted, this would be a complete defense because the premises have zero value. Other defenses that come up in non-payment cases, we see miscalculation of a tenant's share. If a landlord alleges that that the tenant owes a certain amount, and the tenant believes that, for example, the site-based subsidy provider has failed to properly consider or has failed to properly complete the recertification and take into account, for example, an interim recertification that reported a loss in income that would then reduce the tenant's share. That can be a defense. In rent-controlled housing, if there is a rent increase that is taken illegally, then that can be a defense. If a landlord attempts to convert other fees to rent, that can be a defense. And there are both statutory limitations on this and limitations in the federal and local regs. And for folks with portable vouchers, there are explicit limitations in the HAP contract. That's the three-way contract that the landlord, DCHA, and the tenant sign that prohibit some of that. Also prohibited under law, legal fees or attorney's fees, other than there are a couple filing fees that a landlord can recoup if they get a judgment in a writ, and we'll talk about that later. But attorney's fees, legal fees are explicitly prohibited from being collected under law, and then also late fees. So late fees are very common in DC, and if a tenant has a non-payment case, very frequently you'll see that a landlord has added late fees to the claim. Now, landlords are allowed to pursue late fees, but the manner in which they're allowed to pursue them and the amount in which they are allowed to allege them are limited, and the council has kind of tightened those requirements over the past 7 or so years, most recently with the Late Fee Fairness Amendment Act. So a tenant cannot be evicted solely on the basis of non-payment of a late fee. So there's a late fee, a landlord cannot bring a non-payment case just based on the late fee. Also, if a tenant is redeeming a tenancy, which we'll see later, they cannot, that is not part of the redemption amount. Then other protections on late fees. So there is a cap on the amount. Landlords cannot charge more than 5% of rent as late fee. And for folks who have subsidies that have a contract rent amount, that is 5% of the tenant portion of rent, not 5% of the contract amount. There also needs to be at least a 5-day grace period, though a lease can specify more, but a landlord cannot, for example, have rent become due on the 1st, charge a late fee on the 3rd. The late fee cannot be charged to late payment by the subsidy provider. So the housing authority makes its payment on the 6th. The tenant cannot be on the hook for a late fee, and late fees cannot be double charged, which is something that we see landlords do a lot. So for example, because landlords, what they will often do in order to try to preserve statute of limitations issues is they will say that they are always applying any payment to the earliest debt that is on the ledger. Whether they can do that is another matter, but what they definitely cannot do with it very explicitly under the late fee law is that if someone does not pay January and then they pay February, the landlord cannot say that that February payment was paid for the January rent and therefore you are late on both January and February.
Thank you. Okay, so in addition to defenses, which we've been talking about so far, there are other things to think about when you're filing an answer or a response in a non-payment of rent case. And those are sort of affirmative counterclaims, recoupment, and a set-off. And I'll talk about the differences briefly, but I think that for the most part, this is a very useful reference slide when you're thinking about your responsive pleadings. So a recoupment, first, is an equitable defense that seeks to offset the amount of rent, the amount of unpaid rent. And you can use it when there are housing code violations on the premises or have been housing code violations on the premises while the tenant has lived there. It's limited to the amount of rent sought. So what it does is it decreases the amount that the tenant is alleged to owe. And it's an equitable defense, so there's no statute of limitations. It goes back to the initiation of tenancy, though the defense or the plaintiff might argue that they're time limited by latches. There's a counterclaim, and this is like a counterclaim for money that could apply to rent overpayments that are made to the landlord while the property was not in substantial compliance with the housing code. Unlike recoupment, it can exceed the amount sued for, but it is subject to the 3-year statute of limitations. And counterclaims do survive dismissal of a landlord's claims. So you can end up litigating sort of an affirmative case against the landlord if their claims are otherwise dismissed. A set-off is for expenditures that have been made by the tenant that can be claimed as credits against the rent. And so the classic example is tenant made repairs to the unit when the landlord refused to do so. It is subject to the 3-year statute of limitations for contract claims, and some non-repair expenditures can count, like payment for utilities that are the landlord's responsibility. For a hotel, if they have been constructively evicted and the landlord didn't address it. Quick note on all 3 claims that by filing a counterclaim for money judgment, the tenant does submit to the court's jurisdiction. So a money judgment could be entered against the tenant, even if the tenant was not previously personally served. And so it's something to think about and counsel your client about, and talk to your mentor about the risks if you have questions. The rule does not apply to tenant filing recoupment, set-off, or a counterclaim just for repairs. And then important to think about are issues of claim and issue preclusion. The landlord sometimes will claim that counterclaim cannot reach back further than the most recent judgment, including consent judgments, because of claim or issue preclusion. The Court of Appeals has rejected this reasoning, but it's a thing to keep in mind.
All right. So some other important concepts, general concepts that come up at different stages of litigation. The idea of redemption, which is an equitable principle and it mirrors the right to redeem in foreclosure. A tenant that is sued for non-payment of rent, even if the case goes to trial or if they get a default, there's a judgment against them up until the moment that the marshal service carries out the physical eviction, changing the locks. The tenant can redeem their tenancy by paying off what is owed to the landlord, and tendering the full amount that is paid, and then the judgment is not permitted to be executed. There is also a right to cure for lease violation cases. This does not apply to criminal activity cases that are subject to what is commonly called the one-strike provision. So one-strike cases, there'll be a notice to vacate instead of a notice to cure. But for lease violation cases, there is an ability to cure the violation. The landlord needs to lay out in the notice, and we'll go into what the contents of the notice later in the presentation. What needs to be laid out is what the tenant needs to do in order to cure the violation. That is, if there is an unauthorized animal, the landlord needs to lay out what the tenant needs to do to cure the violation, get the unauthorized animal out of the apartment, things of that nature. There is, as we've discussed, a general right to a habitable unit. So tenants have the right to decent, safe, sanitary housing that meets the requirements of the Housing Code and Property Maintenance Code. This is an implied warranty in all rental units in DC, and it is a non-reciprocal obligation. That is, if a tenant fails to pay rent, it does not mean that the landlord has any ability to fail to maintain the premises in accordance with the Housing Code. Other rights of tenants, there's the right to protection from retaliation and from discrimination. We'll talk about how discrimination can be used as a defense in some of these cases as well. A right of first refusal and a right to vote on condo or cooperative conversion. Those relate generally to the Tenant Opportunity to Purchase Act, or TOPA. You will not necessarily see these come up in the context of landlord-tenant cases very often, and probably less common still in cases where there is a subsidy, especially a site-based subsidy attached. So moving on to the 1B cases, the lease violation cases. So what does a landlord need to allege, to prove, in order to meet their prima facie case for a lease violation case? Like a non-payment case, they need to prove the existence of a landlord-tenant relationship, which they will usually prove with the lease. They need to prove that there was some specific violation of an obligation of tenancy. And that obligation of tenancy needs to be a written obligation that is contained in the lease or in the Housing Code. It must be a substantial violation. It cannot be de minimis. That's a defense. They need to prove that they have properly served a legally sufficient notice to quit, correct, or vacate as applicable. And again, when we get into the notice section, we'll talk about some of the contents that need to go into those notices and what needs to be done to properly serve them. and then there needs to be a failure to cure or vacate as applicable within 30 days. So requirements in a valid notice to quit, notice to correct, notice to vacate, notice to cure, all of those are different ways of referring to essentially what is, for legal purposes, the same document. And so there are different forms of it sometimes depending on whether there is an opportunity to cure, but the statutory and regulatory requirements for what goes into it are all in the same section of the regs. So this is essentially a letter to the tenant that is letting the tenant know that the landlord has a valid reason to seek possession of the unit and that the tenant needs to either cure or vacate before the expiration of the notice, or that the landlord will file in court. So there needs to be a specific factual basis that lays out, as the DC municipal regulations say, insufficient detail to allow a reasonable person in the circumstances to know what allegedly occurred. So this comes up a lot because we get a lot of these 1B cases where a landlord is alleging that the tenant is noisy. And so if there's an allegation that a tenant is noisy, what needs to actually go in the notice is, on X date, your household, you were running down the hallway and at 2 a.m. and yelling at your neighbors, and in order to cure, you need to not do that. A legally sufficient notice to quit cannot simply say, you are making excessive noise, stop it. There needs to be a specific reference to the lease provision or regulation that is alleged to have been violated, and a specific description of how to cure. Which, again, like the specific allegation of the violation, is something that we frequently do not see landlords properly do. The expiration of a valid notice to quit is a condition precedent to filing a suit. And so that Moody is the case that alleges this, and what that means is that if a valid notice has not been served and expired, then there is a 12B defense then that can arise. This notice requirement cannot be waived, it cannot be modified, and the landlord has the burden of proof to show that they have served the notice and that the notice is what it purports to be.
That's upside down. Oh. A couple notes on the timing of the notice to quit. A landlord can't sue until the 30 days in the notice has expired. So if someone gets served with a notice saying that they're too loud on April 4th, they can't be sued until May 5th. I think, yeah. For cases alleging consistent late payment of rent, it has to be 30 days. It has to be 30 days, but it also has to be like after the next rental period. So because the cure would be paying their rent on time, you have to give them that opportunity to do so. The notice, for most cases, except for public housing, must allege violations that have happened within the last 6 months. You can't say, 3 years ago, you were running down the hallway. In public housing cases, they have longer. If the tenant cures during the 30-day period, but later violates the lease again, our argument is that a new notice must be served. And I think, you can talk to your mentor about sort of specifics there if they come up. Just like non-payment of rent, our clients have a lot of defenses in these cases. Number one, I didn't that didn't happen, or it didn't happen the way that they say it happened, or denial of the violation altogether, or that happened, but it's not a violation of my lease. That the violation was cured. Yeah, they told me to, they told me I had an unauthorized dog. I got rid of the dog within 30 days, so they should not be able to sue me. The violation is de minimis, or forfeiture is not warranted. Like, there any sort of, the consistent late payment was on the 6th of every month. Waiver is saying that, like, they continue to accept my rent after they gave this to me, and so they've waived. Talk to your mentor about asserting this one as well. The landlord has acquiesced. They've been letting me have a dog for 4 years. Why are they suing me for it now? Or retaliation, like, I complained about them to the city, and now they're complaining about me and trying to evict me. And so some of the defenses are available in the DC Human Rights Act, which prohibits discrimination against people and requires landlords to provide reasonable accommodation for individuals with disabilities or other protected categories. And so this comes up when the landlord is complaining about, the person with kids being too loud. You can bring up a defense that they're being discriminated against for their familial status. There's also defenses within the Federal Fair Housing Act, which is not as broad.
To expand a little further on disability issues, landlords will either be, covered or if applicable. So Section 504 applies to public housing, and it applies to site-based subsidized housing. It does not apply to voucher landlords. The ADA applies to public housing owned by DCHA and to how DCHA administers all of its programs, including the Housing Choice Voucher Program. So if there are ADA or 504 defenses, those may be applicable. There is also a defense, a complete defense, if the conduct, the alleged violation is the result of an intrafamily offense, domestic violence. This is a complete bar. So, for example, a tenant who is the primary leaseholder is the victim of a domestic violence incident. Their partner assaults them with a weapon that is illegal to possess. A landlord then, files a case saying that you as the household member, or one of your household members was in possession of an illegal weapon. And we're filing this case. It is a complete defense in this case to say that this case arises from an incident in which the tenant was the victim of an intrafamily offense.
I think we have one question on that.
Yes. 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 So,
just to repeat the question,
okay.
The question was the ADA applies when to how a DCHA administers its programs. So does that mean it applies to voucher landlords?
And so the answer is yes. So there is so DCHA has an office that handles both ADA and 504. It's the office of the ADA 504 coordinator, and so Section 504 is not applicable to private landlords who own and operate the properties where voucher holding tenants reside, but the ADA is.
And so to follow up on that, ADA does not apply to HUD site-based.
The question is, does the ADA apply to HUD site-based housing?
I think both apply. Yeah, I think both apply. Yeah. So the ADA is broader, and 504 is more. I don't know if restrictive is the right word. 504 has more requirements in it than the ADA. The ADA applies to more landlords. So reasonable accommodations, so kind of going back to the ADA 504 requirements, this is a request for a change in the rules or policies that a landlord has. So examples of reasonable accommodations that can come up a lot, an allegation that a tenant is in violation of their lease because they are very messy and they're hoarding and it's causing an infestation. If that hoarding is connected to a disability, a tenant can request a reasonable accommodation to give them time to engage in services, to give them extra time to cure that hoarding violation. If there is an allegation that there's an unauthorized animal in the unit, this is a very common one. The waiver of a no pet rule to allow for therapy or a support animal. A reasonable accommodation can be requested to allow the tenant to transfer to another apartment. If there are things that are triggering in the apartment where they currently are, or if there are mobility concerns, then a tenant can request a reasonable accommodation to transfer. A tenant can also even request additional time to cure any lease violation. And the really important thing about these reasonable accommodations is that there's not really a time limit on them. So, if you are in court, the mere fact that there, is this alleged violation of a lease obligation that has not been cured does not prohibit a tenant from requesting, 4 months after the case was filed, a reasonable accommodation allowing them additional time to cure. Other common issues that we see, unauthorized occupants. This is a really common one in subsidies because a lot of recertification paperwork is pretty onerous. All household occupants need to be approved and listed on subsidy paperwork and the lease. Depending on the program, sometimes the programs do not allow adult family members to be added except in limited circumstances. New adult family members can also be subject to some screening, though there are some limitations now on tenant screening in DC. But a tenant should be able to add children or minors with a caretaking relationship. They should be able to add a spouse, should be able to add a live-in aid, but important flag for live-in aid. Live-in aid is essentially a reasonable accommodation, and we've seen kind of a number of times where tenants who are maybe caretakers of an elderly head of household, they want to be the caretaker, and so they say, "Oh, I'll be the live-in aid," and they say that without sometimes realizing that live-in aid actually confers no survivorship benefits. So that is something to consider. Whether if there is an opportunity for somebody to be added as a household member as opposed to as a live-in aid, the potential survivorship. All occupants, except for live-in aides, have their income calculated as part of the rent calculation, with the exception of full-time students' income. So if there is a household member, the adult the adult child, in the way that someone who's 19 is an adult, their income is not calculated as part of the household member if they are a full-time student.
All right. So one common cause for eviction for subsidized tenants, or cause for cases against subsidized tenants, is if is having unauthorized occupants, living with you in a subsidized unit, and then the landlord finds out about it. It can result in a debt being owed once the occupant is added and the occupant's income is added, and the rent can be retroactively increased, or it can result in a notice being served, and there's still a right to cure if you have an unauthorized occupant by removing the person who's an alleged unauthorized occupant or properly adding them to your lease. Each program also has rules for removing household members who have left, which is very important for income calculation and for criminal activity.
The question is, if an unauthorized occupant is properly added, is the debt still there?
Yeah, they would be. Yeah, and it would go retroactive to when their tenancy began. We have some questions coming in through the chat. Let me go through them one by one, and then we'll keep going on failure to recertify. So examples of substantive violations of obligations of tenancy versus what might be considered de minimis. So substantive violations, I think this is a point that's really important time for tenants to have lawyers, because these are all sort of subject to argument. But substantial violations are, threats against tenants, management, public urination or nudity, other substantial violations that you can think of.
I mean, really, it depends what you can get a DC jury to think is substantial.
Possession of a machete, for example.
Not substantial.
Not substantial. What might be considered de minimis, paying your rent a couple days late, doing something only one time and then fixing it. I think these are all subject to argument, and, having a good lawyer on a tenant's side is really helpful for that. If an aide stays overnight only when needed, does that qualify as a live-in aide? Each program has their own rules about frequency of visitors. Occasional overnight would be considered a visitor, I think.
Yeah, but I would also think that if there are occasional overnights for someone, that would also be subject to potential reasonable accommodation request. If the program had limitations on overnight stays, but the person who is staying, more than the program technically allowed, was doing so for a reason connected with the tenant's disability.
This is a great one. What if two tenants, I'm going to let you answer this one. What if two tenants' rights are in conflict? Example, violation of warranty of habitability defense based on another tenant's protected status. Upstairs tenant is disruptive because their disabled child is loud.
This is an interesting question. It comes down to who we represent. Yeah. And I think there is a little bit of distinction there to be made between the warranty of habitability and the covenant of quiet enjoyment. An upstairs tenant being loud is not a breach of the implied warranty of habitability necessarily, because there's no failure to repair, there's no breach of the housing code. But it could be, if the landlord is not taking some kind of reasonable steps, then there could be potentially a claim that, could get brought outside of the landlord and tenant court context where defenses and counterclaims are limited. Maybe an affirmative civil claim that the landlord is in breach of the covenant of quiet use and enjoyment.
Yeah, I think that, if we're representing the tenant who's complaining about the loud upstairs neighbor in a non-payment of rent case, that is not a defense to the non-payment of rent case. If we're representing the upstairs neighbor because they're trying to evict them for the disabled child being too loud, that is a complete defense saying, like, you're discriminating against my disabled child.
Yeah. But, there could be, for example, you can think creatively sometimes about if there are issues with neighbors. Remember that there's a lot of flexibility within the reasonable accommodation process. So, for example, a tenant is living in, a corner of the apartment complex with very loud neighbors, and that tenant, needs, in particular, they need at least 10 hours of sleep uninterrupted because they have some medical condition. You can get the doctor's note saying that it's really important for the tenant's health that they have this kind of quiet area, and then send the reasonable accommodation to the landlord and ask the landlord to transfer them to another part of the complex.
Yeah. Okay, next question. What happens if a voucher holder dies, leaving behind minor children? Can someone else in the family step into a voucher holder's shoes?
Let's see. I think that, so a voucher cannot be held by a minor as head of household. I think there would need to be some...
There would need to be a custody determination.
There would need to be a custody determination, and I think it would be much easier if the successor were living there. I think that DCHA is pretty restrictive, frequently more so than the regulations say they should be on successorship. So, I don't want to give like my 100% answer without looking at what the CFR says, but I think if there's no household member, then the minor children might be in a tight spot.
Sarah?
Yeah, sorry, this is Sarah from RFJ. I don't know if you're going to need.
We'll have to repeat it.
We can repeat it.
Yeah, I'm currently litigating a case on this issue. It's going to depend on what exactly the subsidy is, because the regulations are different. But generally, most of them, again, it's going to depend on what subsidy it is, but generally there's regulations that suggest what is arguably a requirement to allow an adult either have a guardian assigned by the court or to allow an adult in as a guardian.
Yeah. Okay, so we're not going to be able to repeat that whole thing. Sarah from RFJ is litigating a case. If you're mentored by Sarah from RFJ, you're in luck if you have this question. Otherwise, you could ask your mentor, but it largely depends on the specific type of subsidy. 2 more quick questions, and then we need to move on to finish the remainder of this section. When does a temporary guest become a relevant occupant? Again, it depends on the subsidy, so you need to look at the regulations. What happens if a tenant marries a live-in aide? Are they required to report it?
I would always err on the side of reporting things. Yeah, that is a very law school question. That seems like a change in household composition to me. So along with changes in income, you are required to, report changes in household composition. Marrying your live-in aide, I think there's some pros and cons to that. An obvious con is that if they are no longer a live-in aide and they have a household income, then that is now calculated as part of the household income for calculation of the tenant portion. But the obvious pro is that if you die then your now spouse can step in and inherit the voucher. So
An obvious pro.
obvious pro, except in the case of a kind of Black Widow scenario.
Okay, moving on. Another common issue that we see in these cases is eviction for failure to recertify. In public housing, failure to recertify can result in someone getting a notice to correct or vacate. It's treated as a lease violation. It can be cured. There's an administrative process available, but generally you'll do it through the eviction case. In site-based Section 8 results in a rent increase to market rent and or a notice to correct or vacate. So the way that this plays out, if it's a rent increase to market rent, then your client will be coming to court with a huge non-payment of rent balance, and what you're trying to do is get a retroactive recertification to get the balance down. These might be harder to come through right to counsel. We'll see. They can also be treated as a lease violation subject to cure. It's sort of up to the landlord's lawyer how they're going to file that case. There's no administrative process to challenge, though you can request a meeting with the rental office. In the voucher program, DCHA will issue a recommendation for termination to the voucher holder. The voucher holder can challenge the termination through an administrative appeal process. Sometimes you'll see this happening in tandem with a non-payment of rent case or another eviction case. DCHA can stop the payments to the landlord, again, resulting in that non-payment of rent case I was just mentioning. A couple other common issues, real quick.
Oh, yeah. So just 2 more slides on this section, and then we'll go to the next. So other recertification issues, failure to report a new or higher income. So there is an ongoing obligation to report changes in income. If a tenant loses income, then they have a lot of incentive to report it, because when you report the income is when the landlord's obligation to downwardly adjust your tenant portion kicks in, and that is true and can be backdated. So, for example, you report your loss in income on November 30th, and the landlord takes a month to calculate it. They still have to retroactively charge you that lower income for the December 1st portion. But if your income increases, you have the obligation to report that to the landlord as soon as your income does increase. And if you fail to do so for a period of some time, so for example, what we see in this comes up in a good number of cases, is someone's income increases and they don't report it until their next annual or biannual recertification. And the landlord, says, well, when did this income change? You say, well, I've been making this for 10 months. The landlord can actually backdate the tenant portion and say, actually, you should be on the hook for the higher tenant portion for those last 10 months when you did not report it. There is a statute of limitations issue that can come up if the debt is not acted on for more than 3 years. I think, like I flagged, the decrease in income is actually not so much a tenant obligation as a tenant kind of advice and counsel that you should do it right away. Other issues that come up, issues verifying income or household composition. So the easiest verification is, if a tenant has steady employment and a responsive employer who picks up the phone or answers their email when the housing authority contacts them. But there is some guidance on alternative verification procedures. So, sometimes employers, especially kind of past employers, if a tenant has been discharged from their employment, are very reluctant or very lazy about responding to the housing authority. And in those cases, There is, as a method of kind of last resort, an option for a tenant to do for example, like a sworn and notarized zero income statement, for example. Other things that come up, if a tenant's income has a lot of fluctuation, if they're doing a lot of part-time work, gig work, you should take a look at what the regs say on how to calculate it. There are different methods of calculation. It can depend on the type of subsidy. You should consult the CFR and the Green Book, which your mentor should have access to, and or should be able to give you access to come up with the best way to kind of go about that. And that is the end of this section.
Do we have any other questions coming through? No? Okay, then I would like to introduce my colleague, Molly Katchen. Molly is the mentor for any attorneys taking cases through Kroll. Anyone in the room with Kroll? Great, so when you take a case, Molly will be your mentor. All right, Molly's going to be talking about some technical defenses that are at play in these cases. Let's go ahead, see if you can finish before break, but if not, we're going to be taking a break in 15 or 20 minutes.
I think we can do this
Okay.
in 15 or 20 minutes. Hi, I'm Molly Katchen. I'm a supervising attorney at Legal Aid, and so I'm going to talk, hopefully, pretty briefly so we can get you to break, about technical defenses that can be raised. So just sort of a note at the beginning, a lot of these defenses, if you took cases pre-COVID, there's been a lot of changes in the law, which you'll hear about, and a lot more requirements put on landlords in filing cases, most of which have been beneficial to tenants. And so a lot of these technical defenses that we're generally raising these days were not issues previously. So these are all new issues that are currently being sort of, some litigated in the court, some pretty clear. So just if you took cases previously, just make sure you're thinking about all of these things when you get a new case. So the first technical defense that can be raised, and these are all things that would be raised in a motion to dismiss, either at the initial hearing, prior to initial hearing, or the further initial hearing if that's where you're getting involved. But basically prior to an answer being filed is when you would file a motion to dismiss. So owners must have a current basic business license before filing an eviction case. They also have to be registered as covered or exempt from the rent stabilization program and provide the registration or exemption number. And the way this plays out is there's a spot on the new complaint form for the registration or exemption number to be there, and they have to attach a copy of the business license to the complaint paperwork when it's filed. The other sort of next step in sort of the defective technical defenses is defective pleading. So under the Iqbal-Twombly standard, the landlord must plead sufficient facts to make out a plausible claim for relief. So legal labels alone are not sufficient to make out a plausible claim for relief. An example of this is, as you previously heard, a landlord in a notice to quit case, there has to be a requirement that there was a failure to cure. So that failure to cure must be pled on the complaint. If the landlord didn't plead a failure to cure on the complaint, they haven't made out a plausible claim for relief. And so that would be a basis for dismissal as well. So this notices, so under the new relatively new legislation, post-pandemic legislation, in all non-payment of rent cases, notices of past due rent or an intent to file a claim are required. It's not, as Adam said, it's not waivable. And so this notice has to be served prior to a case being filed. It has to be served on a tenant at least 30 days prior to the eviction case being filed. The notice also has to contain some very specific language or language that's substantially similar to what's laid out in the regulation. So just take a look at the regulation to 42350501. Generally these days, a lot of the notices are to contain this language, but it's possible that it's not in a notice, so make sure you're looking very closely. Some things to keep in mind, they have to have, a statement that only a court can order your eviction. It has to have information about the Landlord-Tenant Legal Assistance Network and the phone number. So if any of those things are not contained in the notice that's served in a non-payment of rent case, that would be a basis for dismissal. For notice to quit cases, There also is a notice requirement. The notice has to contain sufficiently specific language about the alleged lease violation, state a minimum time to vacate, include the rent control registration or exemption number. The notice must be served in English and Spanish, or if the landlord knows the tenant speaks another language, primarily speaks another language other than English or Spanish, and that language is covered by the DC Language Access Act. The notice should also be served in that language. If you have that issue, I would speak to your landlord, speak to your mentor, because sometimes those are a little bit complicated. So both notices to quit and notices of intent to file a claim or notice of past due rent have to be served on the tenant. They either have to be served by personal service, substituted service, or posting and mailing. If the notice is served by posting and mailing, the landlord has to provide a copy of a time-stamped photograph of the notice posted on the tenant's door. They have to serve the tenant first. Then in notice to quit cases, it gets served on the rent administrator. So these are all things to just keep in mind when you're looking at the paperwork to make sure the service requirements were properly followed, and if not, those can be raised in a motion to dismiss. So dismissal is required for some of these technical defenses. Specifically, if the landlord fails to provide either of the two required notices, a case cannot proceed. If the landlord files an eviction case prior to the time period in the notice expiring, if the landlord does not have a photograph with a date stamped for service when notice is posted, or if there's language issues and the notice hasn't been served in the proper language. Also, in notice to quit cases, there's additional requirements that the notice include language related to rights of victims of interfamily offenses. And so if that language is not in the notice, that's also a basis for the case to be dismissed. And in certain federally subsidized tenancies, the landlord also has to serve, along with the notice to quit, notices under VAWA with respect to eviction. So if you have like those situations, the federal regulations list out which specific subsidies are required to have the VAWA notices, but that's just something to keep in mind if you have a case like that. So the complaint paperwork must be served on the tenant at least 30 days prior to the initial hearing, and that is excluding Sundays and legal holidays, so it's more than 30 days. Personal service is the preferred method. However, it frequently does not happen, and usually cases are served via posting and mailing, so make sure you're looking for that photograph. Posting and mailing is only supposed to happen after diligent efforts were unsuccessful in personal service. Diligent efforts require 2 different days at 2 different times, attempts at personal service. Again, you can look in the declaration of service to see if that's in there, and if something seems a little weird or off, those are certainly things to challenge. You can talk to your client about the times the process server said they came, like, are you home every day at 8:30 in the morning, or are you home generally at 8:30 at night? And, oftentimes a tenant will say, yes, I'm always home at that time because I'm getting my kid ready for school and no one ever knocked on my door. So those are things that can be challenged, and so just to keep in mind. After service, the process server has to complete a declaration of service form. Those forms are entitled to the presumption of accuracy. That does not mean they cannot be challenged, and we do often challenge them. So if your client is telling you something that is totally different than what the affidavit of service said, you should certainly raise that. The affidavit of service is supposed to be filed 21 days prior to the initial hearing, or the case is supposed to be dismissed. So for all of these technical defenses, the judge may raise them on their own and dismiss the cases sua sponte. It sort of depends. A lot of times you'll hear in the beginning of a case, the court say, we have notes on a case, and that means that the judge or the attorney advisor has looked at the pleadings and found that there's something missing or something improper. So it's possible the court could raise it on its own, but I wouldn't, you should not rely on that. And so you should look through all of the pleadings, as soon as you get the case, and be prepared to either file a motion, preferably file a motion to dismiss prior to that hearing so that all of the issues are raised. Things can also be raised orally at hearings. The courts will sometimes tell you to put the motion in writing. But, generally you just want to make sure that you're prepared with all the issues and not relying on the court to sort of flag things. Because sometimes they do, sometimes they don't. There are some things that they typically flag, some things that we're sort of, pushing back on a little bit. So it's important to just sort of think through all of these possible defenses and possible bases for a motion to dismiss when you get your court paperwork. It is possible that the court, will allow the landlord time to cure some of these technical defenses. For example, if a basic business license was not included with the court paperwork, but the landlord or the attorney represents at the hearing that they do have it and it was just an oversight that it was not included, we should certainly be pushing back on that. However, the court will likely give them time to amend the pleadings and supplement it.
We're going to go ahead and move forward, which is another sort of practical implementation, what these cases look like in as they move through the landlord-tenant court process. Our colleague Sunny from LCE was not available today to come. Something came up, and so Adam is going to be explaining this part to us as well. Thanks, Adam.
Yeah, so bad news, Sunny isn't here. Worst news, I'm filling in. So like Elena said, we'll be talking about kind of the nuts and bolts of, you get a case, you know what the law is, like, okay, well, how does it actually work in practice? How do the rules of procedure for the landlord-tenant branch operate? So I have here a flow chart that will kind of is an overview, and we'll talk about how this works. And in kind of more detail on each of these steps, but broadly speaking, in any case, after it's filed, it'll be set for an initial hearing, and I won't go into too much detail on what each of these are because they'll all come up. But the case is filed, there's an initial hearing set. Maybe there is a motion to dismiss that you can file. That might get litigated. At some point, you would need to decide whether to continue on the bench trial track or demand a jury, which is a right that tenants have. If there is an issue about what the protective order, and we'll talk about what protective orders are, if there's an issue about what that is, then there might be a hearing on what the protective order should be. If there's a bench trial, then you might want to file a motion for summary judgment. You might want to move for a leave to conduct discovery because it's not a matter of right. The court will set a mediation in any case. And then you'll have your trial. If a case is on the jury trial track, the court will issue a scheduling order, certify it to a calendar judge. There will be discovery as a matter of right, then a mediation. There might be some dispositive motion, litigation at some point after a close of discovery. Then the court will set it for a pretrial conference and then a jury trial. So, like I said, we'll get into each and every one of these as we go. So, one of the first forms that you want to kind of go over and you want to fill out if you can is an application to proceed in forma pauperis, also called an IFP, also called a fee waiver. There are filing fees in court. They are not very high for landlords compared with other jurisdictions, but very notably for our clients, it costs $75 to make a jury demand, $10 to file an answer, $10 to file a motion. So that can really add up. And pretty much all of our clients, especially ones who are eligible for federal subsidies, are going to be eligible for a fee waiver. So you can file this in advance. You can file it at any point, but generally good practice is you would want to file it. If you file it, you can file it along with the answer and jury demand, so that the answer and jury demand are then kind of lodged pending determination of the court that the IFP is granted. The clerks are actually authorized to approve applications for tenants who receive certain income-based subsidies or programs like SNAP, Medicaid, TANF, and because there's DC code on IFPs says that IFPs shall be granted, the clerk can do that. The clerks can do that without any determination from the judge. If someone does not have one of those, there are kind of more questions to fill out on the IFP, and you can then, if the IFP has not been ruled on at the initial hearing, you can mention it to the judge, and the judge will usually then, rule on it, approve it at the hearing. So you show up at the initial hearing, and there is some allegation that your client has not paid rent. Your client thinks that maybe they did pay some of these things. The number doesn't really look correct. What is the landlord required to do? Well, new filing requirements do require, for non-payment cases, that a copy of the ledger going back to zero balance be attached to the complaint and to the notice of past due rent. But in addition to that, there is a discovery rule that existed even prior to those filing requirements. Rule 10 of the landlord and tenant, the rules of civil procedure for the landlord and tenant branch, that says that at every court date in a non-payment case, a landlord must furnish a copy of the ledger going back to zero balance. Now, when we were in person, the rule was that they literally had to have it. But I think that now the rule has been amended to require that upon request at any hearing, the landlord has, I think, 3 days to produce it. So, you show up, you mention it, and then landlord counsel has to give it to you within 3 days. There are actually some sanctions for this that the rule contemplates. If this is not done, the court can continue the matter. The court can order production, under penalty of contempt. The court can decline to kind of process the case further or enter a protective order or modify an existing protective order. So you show up at the initial hearing, and what are the responsive pleadings? So a tenant is not required to file a written answer in the landlord and tenant branch, except if they're requesting a jury demand. As a matter of practice, though, we, the legal service providers and folks we mentor, we do file written answers even in cases where there's no jury. If there is a jury demand made, then a tenant needs to verify the answer and verify the allegations in the answer and jury demand, either through notarization or through execution. That is, I, Adam Marshall, affirm that the foregoing is true and correct to the best of my knowledge under penalty of perjury, executed this 9th day of November or whatever today is. A jury demand must be requested at the initial hearing or further initial hearing, or reserved. The right to a jury demand in DC is a waivable right. So if there is an initial hearing and it gets continued twice for whatever reason, parties are like negotiating and they think they can resolve it, but then all of a sudden, it falls through and, parties want to go to trial. The tenant wants to tenant wants to take, exercise their right to a jury demand, they need to have reserved that right. I think that the rule now says that the first reservation is a freebie, unless there is kind of good cause for it to be waived or it's explicitly waived. But with the second, if you get to like a second further initial hearing, so like a third kind of initial hearing where there's no like certification, no trial or whatever set, you can reach a point where the court could decide that that right to exercise the jury demand has been waived. If there's an answer or an amended answer, you want to include basically everything you can in it: counterclaims, recoupment, set off. Any answer can be amended within 21 days without leave of court. And of course, you can move the court for leave to amend as well. Why would you file a written answer if there is no jury demand? Well, one, as attorneys, we like to have our record complete. But two, if you remember some of our discussions about the substantive defenses, a lot of the substantive defenses have a requirement that some notice be provided to the landlord. So if, for example, you're raising the defense of a breach of implied warranty of habitability, a lot of what gets litigated is a factual dispute is the question of whether the tenant has actually provided notice to the landlord of the violations of the housing code. And what landlords will usually say is two things, I never knew, and when I went to your apartment at 11 o'clock p.m., you wouldn't let me in, so I couldn't make the repairs. Well, if you have, as part of the written record, an answer listing all the housing code violations, then the court has, at the very least, a record that the landlord was, at the very least, put on notice of these violations through the answer. Bench trials, so similar, actually, this is what I was just saying. Written answers are not required, but we file them as a matter of practice. If there is a counterclaim, a recoupment, a set-off, and that includes an injunctive counterclaim, a request that the court enjoin the landlord to make repairs, those need to be filed in writing at least 14 days before the trial, unless you get an extension from the court for good cause. Other responsive pleadings, so, you get to the initial hearing, and there's some defect. The landlord and tenant rules through Rule 2 incorporate a lot of, but not all of, the rules of civil procedure for Superior Court. And one rule that they do incorporate is Rule 12, the dispositive motion defense rule. So for certain ones, if you are raising a 12b4 or 12b5 defense about the process or the service of the process, then that needs to be raised before you file an answer. Other issues like subject matter can be raised at any time or raised by the court. Failure to state a claim can be raised later, but the 12b4, 12b5 ones, you want to make sure that you don't waive if you have them. So motions to dismiss can be based on a number of things: improper service, like I said, and you can also raise the improper service of a legally sufficient notice to quit. Like I mentioned in the notice to quit section, improper service of a legally sufficient notice to quit should be a 12b6 issue, though some judges are, I think, confused on this. So, generally, better safe than sorry. If you have that, you want to file it up front. You can also make a motion to dismiss on the, on Twombly-Iqbal grounds that there are not sufficient facts alleged to support the landlord's claim. Some issues are more appropriate for summary judgment. If things come up in discovery, if the landlord is basically not able to produce sufficient evidence in discovery that there are lease violations, for example, or if, upon review of the landlord's ledger and the notice of rent change from the subsidy, you have, discovered that you believe that there is or should be zero rent owed, that can be subject to a motion for summary judgment later in the process. Protective order. In a non-payment of rent case, the protective order is possibly the single most important consideration and the single thing that will probably, more than any other facet of the case, dictate the course of and even potentially the outcome of the case. A protective order in DC is a court order requiring a tenant to pay prospective rent to the court registry while the case is pending. So DC does not have, like Maryland, for example, has an affirmative escrow action that a tenant can file if there are code violations. DC does not have that, but it does have this. And so this is, its ostensible purpose is to maintain the equipoise between the parties, but in practice, it has been, in a lot of cases, is weaponized by landlords to try to seek sanctions against tenants who are not able to pay it in order to do things like strike a jury demand, strike defenses. So a landlord's right to a protective order only starts from the initial hearing. It can kind of backdate to that initial hearing if the landlord reserves their rights, though if they don't ask for it, then the right to it only starts from the point that they ask for it. If a tenant is able to make protective order payments, then it can be helpful. Having money in the registry shows the ongoing ability of the tenant to make payments to the registry in the amount of the contract rent or in the amount of their tenant portion, and it accumulates a pot of money that can then be used for settlement and can protect a tenant from falling farther behind. That is to say that if a tenant is simply withholding rent and a case goes to trial and the court finds a tenant on the hook for something, then they would need to produce that amount in a lump sum to avoid eviction. But if there's money in the court registry, the court can order that to be, dispersed and offset that against what the tenant owes. It is also for landlords, a guarantee of tenants' solvency. That is a kind of guarantee that while the case is ongoing, the tenant, has some ability to kind of continue paying rent in the future, and a guarantee that the landlord might be able to recoup some of that if they prevail. There are, like I said, sanctions for failure to make protective order payments. The kind of first line of sanctions is to strike a jury demand. So if a tenant makes a jury demand, then it fails to make a protective order payment or makes one late, a landlord can move for protective order sanctions, and the court's usual first inclination, if it is inclined to order sanctions, is to strike the jury demand and remand the case back to the landlord and tenant branch for a bench trial, which is usually faster. But beyond that, there are other sanctions available. The court can strike counterclaims. It can strike some defenses. It can set an expedited trial date. It can even strike all defenses, basically entering a default and setting a case for an ex parte proof hearing at which the landlord would simply kind of put on their prima facie case and get a judgment. Typically, if a tenant is able to make payments prior to the hearing on the sanctions motion, a landlord many landlords' attorneys will withdraw the motion because they know that the court will probably not entertain sanctions. Some landlords' attorneys will continue to kind of prosecute the motion just as a matter of record, but late payment is still a violation. So the court does have the authority in those cases still to enter sanctions, and that is probably kind of more so the case if this is a repeat occurrence, or if, for example, there are four payments missed before the hearing and the money is all paid kind of the day before. Question.
Quick question, clarification.
Yeah.
So when tenants have issues with their landlord and the landlord fails to correct them, instead of filing a tenant's assertion, they would file a instead, or is the tenant's assertion still available then?
So the question is, if a tenant has problems with the landlord, would they file, basically what would they file? And so the protective order only exists in the landlord and tenant branch, or at least the protective order as we're discussing it. There is another court calendar called the Housing Conditions Calendar that exists for tenants to file cases against landlords for injunctive relief. That calendar does not have an escrow mechanism or a court registry mechanism. The protective order is usually not a request made by the tenant in the landlord and tenant branch context, because the protective order has this sanctions regime attached to it that can have pretty severe consequences for slipping up. So a lot of this, what I've been talking about on protective orders, it can be found in Landlord and Tenant Rule 12I. That's the Rules of Civil Procedure for the Landlord and Tenant Branch, Rule 12I. 12I is basically a codification of existing case law. If you look at the comments to it, you'll see kind of all the sites. But it basically mirrors the Court of Appeals case law on protective orders. They can be set at or any time after the initial hearing. Courts can continue hearings on them for parties to gather evidence. They can be requested by either party. So either party does have that right. But like I said, it is much, much more common for a landlord to request one. In fact, there is even a checkbox on the complaint form for a landlord to request one, for the reason that the landlord's bar has essentially adopted as the kind of dominant tactic to file sanctions motions and get jury demands struck, get defenses struck. If a tenant, so a protective order cannot be entered without a hearing. If a tenant contests it, then there needs to be an evidentiary hearing. Generally, it's only applicable in non-payment of rent cases, though it can be requested in other cases. In those 1B lease violation cases, the parties can essentially stipulate that payments can continue to be made by the landlord, and that those payments don't constitute a kind of waiver of the breach through continued acceptance of rent. So protective order is requested, but there's some dispute over what it should be. Maybe there are housing code violations and the tenant thinks that, and you think that the premises, do not warrant the full amount of rent. Maybe there is a dispute as to what the rent amount is. If that's the case, and you cannot agree with the landlord's attorney on what the protective order should be, then you have the right to request a bail hearing. You can imagine Bell italicized because it is the case on it. Bell v. Centillus and its kind of progeny are the cases that outline this right. And it is an evidentiary hearing, pretty similar to kind of a miniature bench trial where parties have the opportunity to present photos, put on testimony, put on inspection reports, investigator testimony on what the code violations are, and based on that, argue to the court what the protective order amount should be. That is at least what a Bell hearing should be. There are some judges, though, whose calendars get very backed up, and they try to litigate a lot of these Bell hearing issues via proffer. So just be prepared for that as well. In cases with subsidies, you'll also see a lot of related issues coming up that have an impact on what a protective order should or can be. So if there is an issue with the income-based rent calculation, then that can be subject to a potential argument at a Bell hearing. If a subsidy has been terminated for landlord violations, then that can come up. And something we see pretty commonly with folks with portable vouchers is that as part of the HAP, the housing assistant payment contract between the tenant, the landlord, and the housing authority, there's a requirement that units are subject to HQS, housing quality standards inspections. And if those units fail those inspections and then fail re-inspection, the housing authority will say, pursuant to that tripartite contract, that you, the tenant, are still a program participant in this portable housing choice voucher program, but the landlord is in breach of their obligations. So we are going to stop payments to this landlord, and we're going to give you a transfer voucher, and we are going to stop those payments in 30 days. And for a lot of tenants, that is not enough time to move. So you have a lot of cases with these portable vouchers where the landlord is arguing that the tenant should be on the hook for the full contract rent, and they're asking for a protective order based on the full contract rent. Well, you can raise as an argument this kind of unclean hands issue that the only reason the full contract rent is at issue is because the landlord failed to maintain the premises in accordance with the housing code. If you do have something like that comes up, that basically anything that comes up that is different from the kind of vanilla Bell hearing about just what the conditions are in the unit, it is very helpful to file some kind of, brief or memorandum of law to set out the issue for the judge. Bench trial versus jury trial, some considerations, and we've kind of alluded to some of these things. Jury trial has more time, and for a lot of our clients, a delay is a win. A jury trial can take 6 to 12 to 15 months. It gives more time for a tenant to prepare, more time for you to prepare, more time for a tenant to stay in their home with a roof over their head, more time for a tenant to seek other housing arrangements, more time for a tenant to recoup lost income, to find a new job. So all of those are inherent benefits in the longer timeline. On the other hand, the longer timeline, if it's a non-payment case especially, can expose the tenant to more possibilities of missing protective order payments. In the plus column for jury trials, they are much more expensive for a landlord with counsel to litigate. It costs them, I think, probably over $10,000 to take a case to jury trial. There's also limited discovery as a matter of right in a jury trial case. There's no discovery as a matter of right in bench trial cases. It used to be mediation only for jury trial track ones, but now there's mediation for both. And if you do make the jury trial demand, it can be withdrawn by consent of the parties. Bench trial is faster. It'll usually be set for, it could be set for as soon as, 5-6 weeks, but it'll usually be set for more like 3 or 4 months out. You get a quicker outcome, which can be especially good if you're seeking injunctive relief. If the client's not able to make a protective order of payment or the case is pretty straightforward, sometimes this will make sense. The code violations might be addressed sooner. It'll just resolve the matter faster. But if you are doing this and you want discovery, then you will need to ask the court for leave to conduct discovery. So if you do make the jury demand, then the court will issue a scheduling order. They will certify it to an associate judge in the civil actions branch, and they'll set a close of discovery and a mediation date. They might also set a pretrial conference date. So the default period of time for a landlord and tenant scheduling order is 60 days for the close of discovery. You might want more, you might want less. Generally, you will schedule mediation, ideally at least like 2 weeks after the close of discovery. But there's a lot of variation according to availability. If the case is not resolved at mediation, and there's no pretrial conference date set, then the assigned judge will set a status hearing and then set a pretrial conference date. Once a case is certified, if you have motions that come up, it is a good idea to look at 2 things. The first is Landlord and Tenant Rule 13I. The second is that calendar judge's standing order. Landlord-Tenant Rule 13I goes over which motions are branch motions and which motions are motions that get heard by the calendar judge. Generally, ones that are branch motions include issues regarding the protective order. Calendar motions include things like pertaining to discovery, for example. Discovery is a matter of right in jury trial cases. Landlord-Tenant Rule 10 outlines this. You have the right to 10 interrogatories and 10 requests for document production. You want to serve these pretty soon after the jury demand is filed because the discovery period is not particularly long for these cases. They're due 30 days after service. And so, the deadline, the absolute deadline to serve them would be 30 days prior to the close of discovery. If you are litigating a summary judgment motion, the deadline for that is to file it within 30 days of the close of discovery. You can move for some additional discovery, including depositions, but generally, and especially if it's not a consent motion, this is still a kind of summary process. This is that is drawn out a bit, so judges tend to be a bit leery of extending discovery. Mediating a case that's set for a jury trial. So typically, you'll have the mediation. It'll be, 2 weeks after or however long after the close of discovery. It'll be done through the court's multi-door dispute resolution branch. 30 days prior to mediation, you'll want to file you will email to the multi-door to the email address they'll provide you on the scheduling order or the mediation notice, a confidential settlement statement outlining your settlement position, and describing, what if any negotiations have been happening. Preparing for mediation, you'll want to come with, if you have, relevant photos or documents or other evidence, because sometimes the factual issues of the case do come up. You'll want to know what your client's position is, what their goals are, what their walkaway point is, different things they'll be open to. And you'll want to kind of prepare them for the mediation process and go over, who the mediator is, the fact that it's confidential, that the mediator is not a judge, that there's no testimony. If mediation doesn't succeed, the next date would be either a status hearing to set a pretrial conference or the pretrial conference itself. Pretrial conference, for this, you want to look at Civil Rule 16, and you will want to count backwards from this. And I think the slide information is off by, I think it's offset by 1 week. I think it's 4 weeks before is it 5 weeks now?
Yeah, it just changed.
It just changed, okay. 5 weeks prior to the pretrial conference, which used to be 4 weeks, you have the 16C meeting where you're supposed to meet and confer, discuss various stipulations, issues presented, discuss the form of the pretrial statement. 4 weeks prior to Rule 16, to the pretrial conference under Rule 16, that is the deadline for any pretrial motions in limine. 1 week prior, and you would have the joint pretrial statement due, and so that would also mean that 2 weeks prior, under the the motion rules, you would need to file any oppositions to motions in limine. At the pretrial conference, you should come prepared to discuss the pretrial statement, any outstanding motions, trial logistics. The judge also might try to get the parties to kind of confer about settlement. And then the jury trial. At the pretrial conference, the judge will schedule the jury trial. Sometimes, if there are ongoing settlement negotiations, or if the judge is not convinced that the parties are prepared to go forward, the judge might continue the pretrial. The trial date might be a mere month away. Sometimes you'll have a jury trial date set and a pretrial conference date set kind of before it. Other times you'll have the pretrial conference date and then the judge will set a jury trial and it'll be, 7 months out or something. Judges usually will, but you can also ask for a final trial readiness status, a week, 2 weeks, 3 weeks before trial to resolve outstanding issues, outstanding objections, evidentiary issues. Judges usually set this for a kind of like final exchange of exhibits, and frequently will hold under advisement motions in limine pertaining to evidence and then rule at them at the trial readiness date. Bench trial track, these cases are heard by the landlord and tenant branch. Everything stays in the branch. There's no scheduling order, just a bench trial date. There's no discovery as a matter of right, and there's no specific judge who is assigned to it until the day of trial. So whoever is sitting on it will be the judge, the magistrate judge that is sitting in the landlord and tenant branch at the time. It is also not unusual for a branch judge not to be able to complete a bench trial in 1 day. Because a lot of these will be set and there will be multiple of them set for a given day, or they might be set after motions that need to be resolved or evidentiary hearings. So be prepared to, appear at a follow-up trial date to conclude it, or be prepared to set a follow-up date for a judge to come back with the ruling. Generally, unless you're very confident in what you have, you do want to try to see if you can get some discovery in bench trial cases, even if it's kind of informally through, negotiated exchange of documents. Sometimes, though, you might need to move the court for leave to conduct this, and because motions can take a while to get heard, you might also want to move the court for leave to continue the bench trial date in order to conduct that discovery. Often, if a judge does grant leave to conduct discovery, they will limit it further in scope even than the jury trial track, limiting it usually to something like 5 interrogatories and 5 requests for production of documents. Motions practice. So like I alluded to, you want to consult Landlord-Tenant Rule 13 and Rule 13I. You also you also want to look at the calendar judge's standing order if it's been calendared. You'll want to figure, which, who it goes to and what rules apply to it. Some motions go to the landlord-tenant branch. If there are motions in the landlord-tenant branch, those are automatically set for a motion hearing, and there is no opposition that is required to be filed, although frequently it's good practice to file an opposition. In a bench trial, all cases go to the branch, but if a case is certified and there is a motion, like a motion for summary judgment, that goes to the calendar judge, then importantly, that is not subject to the automatic motion hearing, and you need to reply in writing, with the deadline that is contained, the 14-day deadline that's contained in the civil rules. Other common motions, motion for a temporary restraining order or for preliminary injunction. If there are severe housing code violations that you want addressed, in this case, and they can't wait until the date of trial, you can move for a TRO or preliminary injunction. That is injunctive relief requiring the landlord to make certain repairs dealing with immediate health safety issues. Other common motions that come up, motion for joinder. This comes up in subsidy context sometimes. If the housing authority is not making payments that they should be making, then you can move to join them. E-filing requirement. So parties represented by counsel in the landlord and tenant branch must use the court's e-filing system through Odyssey on the e-file DC portal. Legal services providers are technically exempt from the requirement, but we generally e-file, but sometimes if we're like at court in person, we are allowed to go to the clerk's office and file. So if y'all aren't registered, you should get registered. And this system is not perfect, which is a bit of an understatement. But you should be aware that there may be processing delays. Sometimes things are not docketed the same day. Sometimes there are issues with the court uploading certain documents. It is a work in progress.
Sometimes your filing is rejected and you don't get notice of it. So always double check your filings. Thanks for that, Adam. We have one question.
Questions? Yes, and then there's a raised hand too.
Yes, so our internet question is, I know in some jurisdiction, reports from local Department of Health or Sanitation are gold standards for proving habitability violations. Is this true in DC as well?
Generally, yes. So the DC, now Department of Buildings, formerly part of DCRA, you can request inspections of residential units. Is generally good practice, very good practice to do so. It creates a written record. It creates a record of the landlord being put on notice of the violations, and it is a government record. So the courts do afford it some degree of reliability. But it is important if you are doing that, it can be good practice to attend the inspection or to prepare your client for it so that they make sure the inspectors don't miss anything. You don't want to be in a position where you're making allegations that certain things are wrong with the unit that are not on the report. Mm-hmm. But yes, generally it's very good practice to get a Department of Buildings inspection for a non-payment of rent case.
Any other questions? All right, great. Introducing my colleague Molly again to talk briefly about working up a landlord-tenant case, add in a little bit of extra.
Okay. So I'm going to try to move through this section rather quickly because of some of the stuff we've already talked about. What do you do when you get your case, right? So the first thing you're going to do is you're going to look through the paperwork. Then you're going to set a client meeting. So at that client meeting, you want to sit down with your client. You want to go over the retainer agreement and make sure they fully understand the scope of representation. It's really helpful to review the retainer orally with the client and read it to them. I generally like to read a paragraph by paragraph and stop and make sure they understand, as opposed to just handing it to them to read and sign. That way you're not making any assumptions, right or wrong, about their literacy level, and you understand that they, know what they're signing. Next thing you should do is go through the interview checklist that's in the Getting Started guide that you will all get when you get a case. And it's also helpful at that meeting to bring any release forms that you think you may need your client to sign, because it's not, you want to do as much as possible in that first meeting. That way you're not having to set subsequent meetings, have your client come back down, follow up with them, to sign one piece of paper. So, you want to think through any release forms that you might need, have them sign it. Even if you don't use it, if you have it signed and you need it down the line, that's always helpful. You should talk to your client about a plan for keeping in touch. One of the most challenging things I think about, working with some of our clients is that staying in touch can be a challenge. It's not true for all clients, but our clients have lots of issues that come up in their life. Their cell phones go on and off. Their numbers change frequently. And so I think, talking to your client about that in the beginning and making sure that there's a plan for keeping in touch. If their phone isn't working, is there someone else you can call? Obviously get consent to talk to that person, to ask for them. Is there like a backup number they have? Do they use email? Do they use text? Kind of the best way to keep in touch with them, because there are times where you may need an answer for them rather quickly and you want to be able to reach them. And you also want to make sure you're keeping in touch with them throughout the case. Talk through generally sort of virtual in-person hearings, what their preferences are, their ability to join calls virtually, by video or by phone. Talk through a general schedule of like what they would expect moving forward with the case, and your expectations about staying in touch and in-person meetings and that kind of stuff. You want to lay that all out in the beginning, so they have, they know what you need from them to be able to participate in the representation. Obviously, you want to look through all the court paperwork. We don't have to go through this again, but you want to see if there's anything missing in the notices, any sort of bases for initial motions to dismiss, and also, types of defenses you want to assert in your answer. Look through the declaration of service, look at, the dates, the times. Is there something strange in the description? Is there a photograph? Does the description of the person match the description of your client? All those kinds of things. Does the photograph match their door? Same with the complaint. Review all the paragraphs, make sure there's nothing missing, make sure the details on the complaint has a box about subsidized housing, check to see whether or not that's checked, just to make sure the complaint is sufficient. You want to talk through the clients with their goals. You want to start early and you want to talk to them about it frequently. Those goals may change throughout the representation, and that's okay, and they don't have to make a final decision in that first interview, but you want to sort of be having a continuing conversation about them, what they want out of this case. Is their goal dismissal? Is their goal repairs? There are clients where there may be a basis to dismiss the case that we would win, but the client really wants repairs, and so a dismissal is not what they want, and so that's something to think about and talk through with them. The risks, the benefits, talk about the kinds of evidence they have. If they haven't taken photographs of their unit and the housing code violations, you want to make sure you want to get those photographs, especially, if they think the landlord will come in and make repairs after the answer is filed and you're going to lose that evidence. So you want to make sure it's preserved. You want to talk to them about, generally sort of the process, how long things are going to take, what court hearings they're expected to be at. It's, maybe appropriate to involve some family members, a caseworker, obviously keeping in mind sort of and explaining to them the rules about confidentiality when a third party is present. But a lot of times a client's caseworker can have a lot of really useful information, or family members can. And so you want to think creatively about who else may have information about the case. The other really important thing to talk through with your clients about is, do they want to move or do they want to stay, and how that could be impacted by the type of subsidy they have, right? Because if you have a tenant who has a voucher, then the calculation is different than if you have a tenant who lives in public housing or a site-based Section 8, where the subsidy, they cannot move the subsidy. Talk through with your client sort of theories of the case, defenses, all of those goals, bench trial, jury trial, explaining the differences, why they'd want one or the other. counterclaims, recoupment, all the stuff that we've previously discussed. You want to make sure your clients understand that, and keep in mind that it may not, you may have to explain things to them more than once. These are difficult concepts even for, lawyers to understand. So someone who's, doesn't have the legal training, it's not always that straightforward. And so it's important to sort of talk through it with them multiple times to make sure they're fully understanding what's going on. You want to do an investigation of their unit, particularly if the housing code violations are a big issue. Go out to the building, take pictures. It's helpful to have a legal assistant or another investigator there so you can put that person on the stand if you need to testify. Collect all documents from your clients, think through if you want to subpoena any records, and just general litigation strategies for a case. It's always helpful to think through all of that stuff up front so you can make a plan, and so you're not scrambling at the last minute right before the hearing, realizing you don't have any evidence for your Bell hearing or for whatever hearing you have next. So I think Adam pretty did a great job of explaining sort of Bell hearings and next, all sort of the next steps in the case. So I'm not going to go through all of that, but there's some notes on here. You have the PowerPoint if you have questions. And I think that is it. Basically, you just want to be keeping in constant communication with your client if you can, talking with them about next steps, making sure they understand, keeping in mind that goals may change throughout the process.
One question so far from the internet. Can you provide some examples of the release forms you mentioned that we would need?
So if your client has a voucher, you may want to have them sign a DCHA release form so you can get copies of those records, particularly if there's been a termination of the subsidy or that's an issue. If your client has, if it's a case where their client has a disability and you think you may be requesting a reasonable accommodation, you may want to have them sign a release form to contact their mental health providers or their doctors in case there's any documentation that you may want to provide, or at least for you to have. We generally have clients sign a general release form as well. If there's a case where there's other, if it's a criminal, I guess we're not really going to be placing too many criminal activity cases, but it's a criminal activity case, you may want, consent to talk to their criminal attorney, just anyone you think you may need to talk to.
Any other questions from the internet? Shula, any other questions from the internet or in the room? Great. Thank you, Molly.
All right. Thank you.
Next, we're going to turn it over to our colleague, Rebecca Lindhurst, the managing attorney at Brentford the City, to give more in-depth information about public and subsidized housing.
Good morning, everyone. How are we feeling? I'm between you and lunch, so I'm sorry. I'll do my best to move us along. And I feel really confined by this mic, so I may do a lot of hand gesturing. Public and subsidized housing. Sorry, what button? Can I click any button? There we go. Does anybody remember the 3 types of subsidized housing? I'm asking for volunteers. Uh-oh. Site-based, also called project-based. Voucher program, so housing choice voucher program. The original, the OG. Public housing, right? So they're up there. Public housing. In public housing, the eviction is the procedure to terminate the subsidy. So DC is a little bit unique here in that in other jurisdictions, they can terminate the subsidy in an administrative way. In DC, they have to, the only way to get rid of a public housing tenant is through eviction. So the subsidy is terminated when someone is evicted. Eviction results in the loss of subsidy. So this is a huge thing to think about in both public housing and site-based Section 8, that if the tenant is evicted, they lose their subsidy. And the waiting list at DCHA, the DC Housing Authority, is closed. So you cannot get on the waiting list. So huge thing to remember is loss of public housing or site-based Section 8. Loss of the unit is loss of the subsidy, and you're unlikely to find another subsidized unit probably in their lifetime. So it's a huge consideration. There is a pre-court grievance process for public housing. It's not super helpful, and we rarely do it. Sometimes it's a way to get information from the housing authority to actually sit down and look at the records or talk to them about why they're claiming what they're claiming against your client. So site-based Section 8, remember, this is the one that is privately owned. Site-based Section 8 eviction, again, is ordinarily the way for termination of the subsidy. The landlord can also terminate for other reasons, and in the event they do that, the tenant then goes to market rent. So remember, tenants paying 30% of their income toward rent, and HUD is making up the rest in site-based Section 8. So when someone is getting a subsidy termination notice, and the most common one is failure to recertify. So if you fail to recertify, the landlord can then say, we are terminating your subsidy, you're going to market rent. And then what happens is the tenant gets sued for not paying the market rent in a non-payment case and eventually evicted. There is an offer of a 10-day meeting that happens in site-based Section 8. It's not, again, fruitful unless you want to go in and sit down with the property manager and have a conversation about what's going on. Housing Choice Voucher Program. So this, again, is administered by the DC Housing Authority. Tenant takes the voucher, goes out into the community, rents from a private landlord. Eviction does not automatically result in the loss of subsidy. Eviction and subsidy termination are two separate processes for voucher tenants. However, there are certain reasons that the housing authority can terminate someone's voucher, and one of them is a serious lease violation, and a serious lease violation is eviction. It's listed as one of the serious lease violations. So again, it's very important to consider this. The loss of subsidy is huge for tenants, and especially tenants in this voucher program. Yes.
Question from the internet. Is there any procedure by which a tenant can cure a failure to recertify in a private voucher?
Private voucher case cure. So if you have a housing choice voucher and you have failed to recertify, yes, usually the housing authority will let your client recertify late. So tenants usually get subsequent notices of their obligation to recertify. If they fail to meet the recertification requirements, there are often ways we can get people or stop the termination of the subsidy. Reasonable accommodation is a good one. Often tenants don't get the notices, and the tenant can request a hearing prior to the final termination of the subsidy. So termination, reasons for termination, DCHA, again, issues a recommendation for termination, and that gives the tenant an opportunity to cure. Again, failure to recertify is a big one. Unauthorized occupants. We once had a client who they claimed she had someone living with her who wasn't supposed to be living with her. She could prove that he wasn't living there, and was able to save her subsidy. Criminal activity, tenant violations of the housing quality standards. So if they come in and inspect, there's supposed to be an annual inspection in the voucher program. If they come in and inspect the apartment and find that the tenant ruined the carpet, the walls have holes in it, the doors are off the hinges, whatever it is, they can recommend a tenant for termination. You can cure that by fixing all of those things. A tenant does have a right to hearing. So again, you request a hearing within 30 days. And ultimately you have an opportunity after that hearing, if you don't like the hearing officer's decision, to appeal to the executive director. And after that appeal, go to the Court of Appeals, which is unclear in the regulations, by the way, which is why we have this case site here that clarifies that you go to the Court of Appeals after the executive director. So thinking about the loss of subsidy, I sort of was emphasizing that in the first slide, but again, Vacating for public housing tenants or subs means that you've lost your subsidy. The one hand, again, in the voucher context, you can take the subsidy with you. So, but if you are evicted, again, it's one of the qualifications for termination of your subsidy. Judgments. So for all programs, eviction for a drug-related criminal activity creates a bar to readmission for federally subsidized housing for 3 years. Let me say that again. If you get evicted for criminal activity that is related to drugs, you are barred from admission to any federally subsidized housing program for 3 years across the country. So even if you move out of DC, take your subsidy to another jurisdiction, or try and apply in another jurisdiction. If you apply in another jurisdiction, you will be barred for 3 years. Eviction for a serious lease violation, again, mandatory termination. Make sure your client understands the risks of all of these things. Is that a question?
Yeah, I think I'm hearing about eviction that bars still apply.
Clemency? No, I don't think it would.
Can you repeat the question, please?
Oh, I'm sorry. If you have clemency for your drug-related conviction, does that still apply? You think it does? Oh, Elena and I are disagreeing.
I think it would, right?
Well, does it seal it? That's the question. Does the clemency seal the record? And if the record becomes expunged?
So, but even if, and this is like another sort of maybe the hypo that we don't know exactly the answer to and requires lawyering. I mean, I think one of the concerns is that not only DCHA sort of finding out about it, but in sort of your self-representation, not disclosing it, and then them finding out about it, and there being some sort of fraud element as well. So it's going to be a very case-by-case analysis. I think we would argue that it should, but would sort of be up to argument.
Yeah, and I think it might be different for clemency versus something that's been expunged. Okay, next. Okay, so we talked about termination, and again, this is in the Housing Choice Voucher Program. So voucher program, again, renting from a private landlord, DCHA. Yes, Elena.
I apologize. Another question from the internet. What is the interaction between state drug law, i.e. more permissive, and federal?
Preemption is the answer. Oh, what is the interaction between state drug laws and the federal regulations? Preemption. We're thinking about constitutional law, folks. So even though DC permits you to use marijuana, you cannot use marijuana on federal land. So don't get caught smoking pot on the mall, but also in public housing. Don't get caught smoking pot in public housing. So termination of the HAP contract. So HAP is the contract between DCHA and the landlord and the tenant that pays the subsidy to the private landlord. Typically, DCHA terminates the landlord for housing quality standards. So you're thinking that, there are all these reasons that tenants can get terminated from the program, right? And that would terminate the contract. There's also termination for landlord violations. So if DCHA goes to property, finds that the landlord is not taking care of that property, it's mouse infested, there's a roof leak, whatever it is, if the landlord fails multiple housing quality standard inspections, DCHA can terminate that contract to the tenant. Or to the landlord, I'm sorry, terminate the contract with the landlord and stop payment to the landlord. The landlord then often sues the tenant for the full contract rent. And that creates a little bit of a pickle for our clients. So DCHA, again, with housing quality standards, they inspect every year, they issue citations. If the landlord doesn't fix them, then again, they will be terminated. If a landlord makes repairs, landlords have 3 opportunities to get an inspection. So if they fail the first, they get a reinspection. If they fail again, they can ask for a third inspection, but they have to pay $75. Is it still $75? $75 for a third inspection. So one of the things you can do is, if you're already in court, you can ask for injunctive relief. You can argue to the court that this is harming the tenant by the landlord not making the repairs, and the landlord should be ordered to make the repairs so as to not result in termination of the subsidy. What happens then is there are a couple of things that are a problem here, and I'm just going to move to the next slide because I think it's all there. So if DCHA stops payment, there is a question of whether the tenant then becomes responsible for the rent. This is not settled law in DC. There is a provision of the CFR that states that the landlord may not require the tenant to pay the landlord's share. This language is also in the HAP contract, so the actual contract between the parties. There's lots of good information in the HAP contract. Make sure you read it. And ultimately, the court's going to have to make a determination of whether your client should pay the landlord's pay the subsidy portion to the landlord. We can't obviously expect upon termination that that tenant moves super quickly, right? So there has to be some sort of consideration of whether the landlord has to eat the cost, right, of having that tenant without the subsidy payment versus the tenant moving within a reasonable time. I will say, as a sort of conspiracy theorist, I'm not usually a conspiracy theorist, but that some landlords who want to get rid of tenants will purposefully not fix things and then hope for the termination of the contract. So just sort of keep that in mind, that those would be the cases where you want to get that injunction to order the landlord to make the repairs. Bell hearing. So Adam talked about Bell versus Tinsolis Realty. Bell hearing is determine whether or not your client is required to pay the rent into the court registry until the case is concluded. If you are in a Bell hearing situation with a voucher tenant or with a terminated project-based tenant, you want to consider what that amount should be paid into the court registry. Is it that 30% of your client's income, or you're going to have to argue against the landlord's position, which is probably the tenant should pay the full contract rent. So there is, we often file a brief in these cases explaining to the court, because they are not as familiar as we'd like with the regulations around subsidized tenants. We have briefs on this if you come across this, but the argument is that your tenant shouldn't have to pay because the termination is the landlord's fault because they didn't make the repairs. I know I'm talking fast, so stop me if you have questions. When you're moving toward trial and you're considering how much your tenant's rent should be abated. So we often ask for abatements in percentages. So, I generally counsel clients, you could get anywhere from a 10% to a 70% abatement. It's how the court determines how much the rent should be reduced each month, that there were housing code violations. The question becomes then, what happens when there's a subsidy in place? Does it get reduced off the contract rent, the full market rent for that apartment, or does it get reduced off of your tenant's portion of rent, that 30% of their income? There is, the basic idea is that the landlord should not benefit simply because the tenant doesn't pay the full market rent, right? And that if the landlord failed to make these repairs, that it should come off of the full market rent. The abatement of rent should come off the full market rent. There is one sort of procedural thing you have to do in these cases, which is to notify the subsidy provider. So in the cases of project-based Section 8, you have to notify HUD that you are filing a counterclaim for an abatement of the rent because the landlord violated the warranty of habitability. If the subsidized provider does not intervene, so HUD rarely intervenes. There was one attorney at HUD who was like hot on this for a while, and then I don't think that person's there anymore, so they're not really intervening. DCHA sometimes intervenes. It's super, random when they decide to intervene. So if they don't intervene, the windfall goes to the tenant. And if they do intervene, and this is from a case where they did intervene, DCHA intervened, and they sat at counsel's table through the whole trial, didn't introduce a lick of evidence, didn't cross-examine anyone, didn't examine anyone, didn't put on any witnesses, and then claimed that they get the benefit of their money back, of the subsidy portion of the money back. That case went to the Court of Appeals, and they agreed that legal aid should get costs from the Housing Authority for litigating that case. It was a super fun decision. So again, filing a motion to intervene on behalf of the subsidy provider will file a motion to intervene in these cases sometimes. There is no deadline set by the court for the intervention. So it could be, you could wait on that letter. You could decide that this is a case that I think is going to settle relatively soon, and maybe we don't need to let them intervene. So the cases on this, again, there's a line of cases on how this all works, and where the subsidy portion or what the abatement looks like in these situations. I don't think we need to do this. Joinder of other parties. So if the tenant is sued for rent that the subsidy provider should have paid, then you can file a motion to join them. So oftentimes we will argue that the tenant should not have been terminated, or your client should not have been terminated from the subsidy program in a voucher situation. So DCHA terminates the tenant's voucher. You are then, the tenant's then sued in landlord-tenant court. You're representing them, and you can say that tenant should not have been terminated, and we need DCHA as a party in this case to properly litigate it. So the joinder rules apply. There's the rules, landlord-tenant rule 3, double I, 3 Roman numeral 2 applies here. And you have to serve them properly as you would serve any other party when you're adding them to the case.
Hello, welcome back. My name is Sarah Plofkin. I'm an attorney with Rising for Justice.
Hi everyone, my name is Walter Blasi. I'm a managing attorney with the DC Bar Pro Bono Center.
And we are here for the last segment of the day to talk about settling landlord-tenant cases. So you can settle a landlord-tenant eviction case at any time in the process. There's many opportunities to negotiate, including on the date of the initial or further initial hearing. But we would generally not recommend that because at that point, a tenant has the least information. At that point, you might not even have a full and valid ledger. If it's a non-payment case, if it's a violation of lease case, you might not have any information at all about what the alleged failure to cure was. You also, almost all initial hearings currently are remote, so there's very little opportunities to negotiate at that point. However, there's other opportunities. These are both to resolve the full case or just to settle individual issues. So resolving motions, especially protective order Bell hearings, it's very normal to see if you can work out an agreement of what the protective order should be without a hearing, resolve motion for sanctions, motions to enforce court orders, etc. And then obviously the main time you have to settle a case is at mediation. There are mediations required in both bench trial and in jury trial cases, but you can also continue to engage in settlement agreement negotiations even if mediation fails at pretrial conferences, at Rule 16 meetings, at the conference itself, or even in the hallway before trial sometimes. So formal mediation in a bench trial case, the court will set a mediation date prior to trial. Normally at the initial hearing, they will set both the mediation and the trial dates. It's usually at least a couple weeks before the trial date, but it can occur at any time. Especially right now, it says mediations are currently remote. But the court has started scheduling in-person mediations as well, and the timeline on those can be a little weird. Sometimes you can get an earlier mediation if it's an in-person mediation. Sometimes it will be a week before trial. If you have moved for discovery in a bench trial case, obviously you want to make sure your mediation date is at a time that will allow mediation to be concluded. You are required to attempt mediation, which means you do need to show up to the hearing. It takes place through the multi-door dispute resolution center. That's for the remote hearings. And then if it's in person, it takes place at Building C. Before you into the mediation, you'll have to sign an agreement to mediate. If it's remote, this will be emailed to you a week or so in advance. And you need to sign it at some point prior to mediation. If it's in person, you can sign the agreement to mediate at the building itself. I will also note here, it's also with the timeline, as I said, there's no set standard timeline. You can also, if you're not ready when you go into mediation, if you can't come to an agreement, you can get the mediation continued for a later date. For jury trial cases, mediation should be scheduled several months after the jury demand is filed, after the close of discovery. And then you normally are required as part of the court order to submit a confidential settlement statement in advance on a court form. In practice, it is best practices to do so, and there will usually be a form submitted requiring you requesting that you submit this settlement agreement. In practice, it's not always done, but it is best practices, especially since all of the information in the confidential settlement statement is things that you should know and should be prepared to discuss going into the mediation. The plaintiff should describe the facts of the case and the claims being raised and the type and the scope of injuries, any monetary or equitable relief being sought. You should describe the facts and defenses being raised as well as any counterclaims. If you also have a sense of how much money you're looking, what sort of abatement you're looking for, how much money you're actually looking to be abated. That's good to know going into mediation.
Thank you, Sarah. So moving on to first of many key concepts. One key concept that we really want to communicate to everyone is the difference between redeemable and non-redeemable judgments, something you might remember from earlier when we were talking about landlord-tenant process. So redeemable judgments and non-payment rent cases mean the tenant can redeem the tenancy or translux by paying the entire amount due plus court costs to stay housed or to prevent the eviction from taking place. And as Adam described before, that's possible all the way through until when the locks are changed as part of the eviction process. This amount could include appropriate fees if the case is about money, even if filed as a lease violation case, for example, claims of defenses or utility fees. And the redemption amount can include late fees or other non-rent fees unless the parties specify in settlement that they can be included. Non-renewal judgments, which is more likely to happen in breach of lease cases or other kinds of cases that are not non-payment rent cases, or where the tenant cannot prevent the eviction by paying what they owe. They can't redeem what's called redeem the tenancy. And this type of judgment is essentially reversible unless there's some other argument, such as vacating a default or some other, often maybe not straightforward argument to get out from underneath that judgment. And so we want to caution that non-renewal judgments as a penalty for breaching a settlement agreement guarantees a judgment and an eviction in almost all cases, as long as the landlord can prove a material breach of that settlement agreement occurred. Usually, if you have a situation where there's a breach of a settlement agreement, the courts can be really focused on the terms of that settlement agreement, and it'll be difficult. It's not impossible, but difficult to get out from under that settlement agreement. So it's really important in non-payment rent cases to be thoughtful or cautious about having your tenant agree to a non-reviewable judgment if they breach, because that would remove the ability for them to avoid eviction by paying whatever is owed under that settlement agreement. So, potentially if there's a move-out agreement, the tenant's agreeing to vacate, that may make sense in those circumstances, but that's something to be really thoughtful about, whether the judgment is redeemable or not, and what that means for the tenant.
All right, so what does a typical settlement actually look like in a non-payment of rent case? So most non-payment of rent cases, if you're going to settle them, it will be either with an abatement or a waiver of outstanding non-payment of rent claims. So you want to either have your client either owe much less than was originally claimed, or ideally owe nothing beyond their rent going forward. When you prepare your when you're trying to settle, it's good to have numbers on hand, taking into account the value of the defenses that you've raised and any alleged counterclaim, and what percent abatement over what relevant time period. If you're seeking both recoupment and a counterclaim, if you recall from earlier, a recoupment, there's no statute of limitations, so that can go back much further than the counterclaim. Depending on how long the housing code violations have been going on, there may be different abatements for amounts for different times. So do your calculations in advance and be ready to argue them. And another thing to think about is what level of abatement would be required for your client to owe nothing, especially when you have a subsidized tenant who is probably not going to have as much capability to get on a payment plan. Think about what can I make the argument that they should owe nothing? Can you make the argument that they should owe nothing and get to keep whatever funds are in the registry from the protective order? And also keep in mind, when you're doing a settlement agreement, the landlord's much more likely to be willing to waive rent that was unpaid and let your clients keep funds in the registry because the money's not in their pocket yet, rather than actually give your client money as part of a counterclaim. If your tenant still owes rent after you agree to whatever abatement you can work out an agreement for, you want to include a reasonable payment plan as part of the settlement. You should have a conversation with your client to make sure whatever payment plan that's suggested is actually realistic. Again, that's especially important if you have someone who's in subsidized housing. They probably have a very limited income, and you want to have a conversation over not just what sort of payment plan is reasonable right now today, but will they be able to keep making those payments several months down the road. You also want to be creative with it. For example, ERAP, I don't think we've spoken much about, but the emergency rental assistance payments, if your client can apply for that ERAP, think about how that might factor in to the to any settlement agreement, but also don't write your settlement agreement to count on them getting the ERAP payment. For public housing and site-based Section 8 payment cases, any repayment plan should be limited to 10% of the person's adjusted household income. And in other subsidized cases as well, that requirement does not exist, but you should look to that as a guide for what a reasonable payment plan might actually be. Landlords usually request that the tenants pay future rent on time. You should try to fight that, though that's usually something that they're pushing for pretty hard. Oh.
I have one question about the abatement percentages.
Yes.
How do you get a sense of kind of what housing conditions and what appropriate abatement percentage is?
Same vibes.
Can you repeat the question?
Yes. Sorry, for the internet, the question was for abatement percentage, how do you calculate them, that percentage essentially? And there was a bit of laughter in the room because I think our answer is vibes, what you can argue. The other thing I would look for is you can look towards what you were granted or what you could get the landlord to agree to as part of the protective order. And then also just be creative with it. Think of how you can think about like how this is limiting your client's ability to use the property and live in the property, and what percentage of their use and enjoyment is being impacted or eliminated.
And I could just add to that briefly.
Yeah.
And just briefly, I think like even if it might be, there's not like clear authority on exactly what percentages would happen for a reduction of rent owed. You do know, you can see like how much rent is allegedly owed, period, and you can look at each month and see how many issues there are, where they got better or worse. And from that, you can get a series of numbers that kind of estimate like what's a good scenario, what's a bad scenario, what's in the middle, and that can be really helpful for you and your client to get a better idea of what concretely might happen when that case goes before a judge or a jury.
Can I ask one follow-up? Which is to that point, then, is there any sense of what might be aggressive, what might be an average abatement, and what might be a minimal, just so that people can feel tethered to, like, it's normal for me to go ask for 80% abatement, or typically it's part of this range, or is it really all over the...
I think it's really hard, and I'm sure everyone is going to have a different response to that. Like, I think if you have a jury trial and you have some, like, again, anecdotally, juries in the district, in our limited, like in the limited sample set that I'm aware of, can be very generous. So you might actually get a pretty high reduction, even for conditions that might not be obviously enormously problematic to you. I think like judges vary a lot and are less sympathetic than juries, in my anecdotal experience. I don't know if people want. I know we need to move along also, but I don't know if you want to add to that.
I was just going to say the question for the people who are on video was how do you, if we could provide some tether for what a reasonable or normal abatement usually is. And the only other thing I'd add, in the interest of moving along, is talk to your mentor about your specific case. Another question.
How and why can you fight the landlord request that tenant pay future rent on time? Isn't this required by the lease anyway?
So the question was how and why can you fight the requested a settlement agreement that the tenant pay future rent on time? Isn't this required by the lease anyway? And the response is well, yes, it's required by the lease, but if they violate the lease, what they can do is they can file a new eviction case against your client. What you want to avoid with any settlement agreement, it's going to have a clause for what happens if your client fails to meet that breaches that settlement agreement, and your client's not going to have all of the protections they're going to have if a new case is filed. So that's the why. In terms of how do you fight it, you can make the point that it's already required in the lease. You can try, if they are really insistent on making the payment plan, making that part of the case, you can try to limit it to the time frame of the settlement agreement. You can give your client more time rather than having it need to be paid on the first of the month, to give them a more reasonable time frame. There's other ways you can build in breathing room for your client. So the other thing that's part of a settlement agreement in a non-payment case, because normally your defense is that there are outstanding repairs that need to be made. There's a breach of the implied warranty of habitability. So you want to make sure you're going to normally include a list of repairs, an addendum that need to be made. You want to make sure you talk with your client about making sure that they can provide access to the landlord to make repairs. You may want to specify dates and times the repairs need to be made by, and that those repairs will be made in the unit on. Also talk with your client, see if you can be anything they're concerned about in terms of repairs being made and access to their unit, and see if you can build that into the settlement. You also want to specify that all repairs must be workmanlike, especially if this has been an issue in the past for the landlord. You may want to require an inspection at the end of the repairs. And that when you're coming up with a list, you obviously will have any previously identified housing code violations. But if there's other things that your client wants fixed and that the landlord will agree to, those things might be really valuable for your client. For example, a lot of places don't replace the carpet regularly. They might not have painted the unit in a while. There's all sorts of repairs that may need to be made that aren't strictly found in the housing code, the DC housing code. And then finally, enforcement mechanisms for repayment agreement provisions. Landlords want to be able to just file a motion seeking, or sorry, landlords can file a motion for a redeemable judgment. Question in the audience.
Just a quick question on the repairs. So are the repairs satisfaction of the tenant, or do you say, so if the workman, whatever the workman provides, that's what you get?
It depends on. Yeah. Oh, sorry. The question was in repairs. The question is it to the satisfaction of the tenant, or to the satisfaction of the landlord, or to the satisfaction of whatever the whatever the landlord chooses to provide? And the answer is it depends on what you put in the settlement agreement. So if you draft the settlement agreement yourself, you can draft it to try to make it more favorable to your client, to allow a third-party inspection, or require a third-party inspection, or require very specific things that need to be done. So a non-payment enforcement mechanisms for the landlords. They can file a motion seeking a redeemable judgment. Remember, we defined redeemable judgment earlier. For missed repayment plan payments and often missed ongoing rent as well. If you can get the landlord to agree, this one's harder, but if you can build in terms that certain numbers of late payments or a certain amount of missed late days, if it are excused. So you might be able to say, well, if the landlord, your client's filing just a couple days late, a couple times during the term of this repayment plan, that shouldn't be grounds for them to file a motion. And then notice periods for the motion. This isn't as important right now because these hearings aren't being set promptly. But according to the rules, they technically only need a notice period of 7 to 10 calendar days. So if you want, in case the courts start moving more quickly, request a longer notice period for that motion, and then also request a requirement that the landlord faxes or emails you a copy of the motion immediately upon filing it, and that can be very important. Because sometimes the clients don't get notice of these motions and don't show up for the hearings. And then for your client, the enforcement mechanisms, you can file a motion seeking specific performance, for example, in order to compel repairs. You can also try to build provisions into the settlement agreement, allowing your client to pay into the court registry until repairs are made, or that if you file a motion to enforce to enforce or compel repairs, that your client be able to start repaying into the court registry, or that specific penalties are built into the settlement agreement. So if they don't make a certain repair by a certain time, your client's rent is automatically abated.
Thank you, Sarah. So now we're moving on to talk about terms in lease violation cases as opposed to non-payment rent cases. And most lease violation cases are settled with dismissal of claims or good conduct agreements, or where necessary, a vacate agreement. And so I really want to emphasize that first question is dismissal possible? Dismissal makes more sense if landlord does not have evidence, either a violation itself or failure to cure, or if tenant has reasonable accommodation or other complete defense, or if tenant is willing to bar a person who is the problem. And generally, anecdotally, I think in many cases, a landlord will dismiss cases at a certain point, especially once litigation costs become higher, say during discovery, for lease violation cases. So it is often, not always, but often a possibility. And that often, if that benefits your client's goals, that's a great outcome that advances their goals. And you want to carefully review discovery in advance and evaluate strength of the landlord's case, and also consider whether you can file a motion for summary judgment, which is a great way to potentially resolve a case and potentially also get more information from the other side. The other option that we just talked about for settlement or resolution, other than going to trial, which might also work best for your client, is a good conduct agreement possible. So you want to have an early, frank discussion with your client about his or her ability to comply, including conduct by other household members and guests, with some kind of good conduct agreement. And that asks what kind of agreement. So these are some important considerations for a good conduct agreement. You want to think about the time period. And so under an agreement like this, often there'll be some time period under which the tenant has to comply with the agreement and do the quote unquote good conduct or not violate that agreement. And afterwards, it's not really necessarily no holds barred, but they will be under the lease and they won't be able to the landlord won't be able to get a remedy against them under the good conduct agreement. So often that time period will be 6 months to 1 year. Longer can be risky, and it's certainly the more concerned you are, or the tenant is concerned that they are about potentially violating the agreement, the more risky it is to have longer time period. So you often will want to limit the time period as much as possible, and apparently 5-year agreements in one-strike public housing cases are more common, which I think might reflect some of the difficulties in litigating those cases and the possible outcome on the merits that compared to that agreement. You also want to define behavior, and this is really important also. You want to define behavior in a way that's as specific, generally, as possible. Instead of saying no noise, say no music after 10 p.m., and this helps avoid your client or your client's household violating that agreement. And likewise, you want to be that frank conversation with your client includes a conversation about what conduct they feel they can or cannot do, or that their household can avoid or not avoid, to avoid getting a situation where you're expediting the eviction through the settlement agreement rather than avoiding the eviction or otherwise meeting the client's goals through the settlement agreement. So consider how broad, general, or difficult for the landlord to prove breach or for the tenant to defend against the alleged breach. So basically, again, like how it's foreseeable that what would be the results of agreeing to this kind of behavior. And you want to describe the conduct as narrowly as possible and define how the breach can be proven. And I talked about this a little bit already, but you also want to consider the enforcement mechanisms, which can have a really big impact as well on how well that settlement agreement serves or doesn't serve your client. So it is typical for a landlord to be able to file a motion seeking a non-reviewable judgment for alleged breach. Oh, we have a question? That is a great question. The question was, what are one-strike cases? So I think we referred to this briefly before when talking about subsidized housing. So there's a set of, in all forms of federally subsidized housing, if it's in the tenant's lease that they don't have a right to cure certain kind of violations defined under federal law, then they don't have a right to cure those violations in a lease violation case. And so those can be, depending on the circumstances, but those often can be very challenging cases, especially if it's, seems like the landlord wouldn't have that much difficulty proving that there was one lease violation that does violate the lease, which does comply with that one strike language. And so going back to enforcement, then another possibility is to request for a longer notice period for the motion, which gives you and your client more opportunity to prepare for any kind of hearing, which might be like a mini trial about what happened or didn't happen to violate that lease. So instead of, you might ask for 15 business days rather than the 7-10 calendar days for motions under the Landlord-Tenant rule, plus a requirement that attorney fax or email copy of the motion to counsel immediately to give you the most heads up possible that this is coming down, that this is an issue. You can request informal discovery as part of the motion process. So landlord must list all witnesses or produce any evidence that we'll use at a hearing and describe the alleged breach with specificity. And you can imagine that you could add more and more sort of procedural safeguards to the remedy to make it more and more sort of like you're having a trial and you have all the protections of having a trial. And if possible, build a notice and a short opportunity to cure before a landlord can file motion. And just generally, this also goes to what Sarah was talking about. I think you want to be really creative about different ways that you could advance your client's goal and help avoid them being in a worse situation because you entered the settlement agreement. So all these terms are ways to try to make that happen. Yes, we have another question.
Yeah, but this one's for me. When should you talk to your mentor when thinking about settling your case?
So the question, which is a great question, is when should you talk to your mentor when you're thinking about settling a case? And I think you should talk to your mentor immediately if you're thinking about settling a case, because I think it'll be really helpful in terms of thinking about the potential terms, the potential offer, the strategy that you're going to be going, negotiation strategy with the other side in terms of what offers and counter offers and what's the worst thing that's still better than going to trial and what's actually worse than going to trial. So maybe you don't want to take that. That's going to be really helpful to talk through with your mentor, both in terms of the substance of the agreement as well as how you'll proceed strategically to try to advance your client's goals. And remember, this is really key. This is about advancing your client's goals, along the lines of what Molly was talking about earlier. So if trial seems better to advance their goals than a settlement agreement, then you don't want to do the settlement agreement. And that's often your leverage to get a better settlement agreement is to hold out for that agreement that actually advances your client's goals.
Which, speaking of your client's goals, move-out agreements. It's often pretty common for a client to say, I actually want to move out of this property, especially if you're raising housing code condition issues as part of the defenses. It may not be a nice place to live. However, a move out should generally be a last resort, legally speaking, for your cases. You want to make sure you fully assess the case through discovery, through fact checking before you agree to a move out. And until you assess with your client, how long will it actually take for them to move? What will it cost? Where will they go? Do they have a backup plan? If they say, well, I think I can move out in 30 days, do they actually have somewhere to go in 30 days? What happens if they can't find somewhere to live? And then also what kind of subsidy they have, because if they have a public or site-based subsidy that is linked to the unit in question, so if they leave the unit, they lose the subsidy, and they might not be able to get another one. So you want to make sure you know what kind of subsidy they have and what the consequences for leaving actually are. Remember, if the landlord tries to bring it up, which they sometimes do, that the lease has expired and say, well, you have to leave because the lease is expired, that is not grounds for recovering possession in the District of Columbia. But the most important thing is to talk about the actual costs, timing, and consequences on the subsidy of a move-out agreement with your client. I'll also say on that point, you don't necessarily, or should I say, you can do a move-out agreement essentially at any time in the process. If your client comes to you before the initial hearing and says, I think I need to leave, there's a lot of case that can keep going before they would actually, even if you think you might ultimately lose the case, there's a lot of time that they can have between now and when they might have to leave. Question?
It was mentioned that there was a limited right to transfer public or project-based housing. When do those apply, and is habitability enough?
Generally, yeah, sorry, the question was, there's a limited right to transfer in public and site-based housing. When do those apply, and is habitability enough? The answer is generally habitability is not going to be enough. Mostly you're looking at cases of domestic violence, and possibly disability and accessibility, but generally domestic violence. Beyond that, I'm going to say talk to your mentor if you think that's a concern, because it's going to be very limited circumstances and we cannot go through them right now. So what kind of form does a move-out agreement take? Sometimes often landlords will request consent judgments with a stay. That means a judgment is entered against your client, but it's stayed until some date. And if your client moves out by that date, the case will be either be dismissed or just the judgment won't enter. Don't agree to that unless you absolutely have to, because that means you don't get to fight the case if your client doesn't leave. There's nothing for you to do. Ideally, you want to make the landlord have to file a motion seeking either a redeemable or a non-redeemable judgment with, again, your notice provisions inside to make sure that you get notice when they file that motion. Alternatively, you can settle the case and set a status date for after the vacate date. And if your client has vacated by that date, then the claims are dismissed. And then if they haven't vacated by that date, the landlord can receive a non-redeemable judgment for possession. That's if you have a formal settlement agreement. You can also try to work something out informally, especially early on in the case. If your client says, I want to move, I have an actionable plan to move, here's when I can move by. If you can talk to the landlord and say, look, they have a move, they want to move, can we set a status hearing for this date? And he or she may have been moved out by then. And sometimes the landlord will agree to that. And then again, never agree to any process where a judgment is automatically entered or a writ is automatically issued. You always want to give yourself and your client the opportunity to raise defenses and make the landlord actually prove your client has not vacated the unit. Question?
Yes, it's an actual plan. Is it go through settlement for like payment purposes? If there were habitability issues?
It's going to depend on, sorry, the question is, if the client has an actionable plan to move, does it make sense to go through settlement for the purposes of trying to get a settlement basically for the benefit of the client, to try to either get an abatement in writing or potentially even some money back to your client? And absolutely, if you have a case where you've got a really strong habitability claim and you think you can get some money back from your client, or you think you can agree to get the landlord to waive the past due amount so that they can't come after your client for the money later, it absolutely makes sense in that case to go through the formal settlement process. And if your client has a good actionable plan at that point to move, that puts you in a really strong negotiating position, because you know that your client is probably going to actually be able to meet that settlement agreement. So other terms that you can include in a move-out agreement, waiver of rent, late fees, all other charges, like just stated. Talk about the security deposit. Does your client get their security deposit back? And can they get some funds from the court registry? And one thing, especially if the landlord wants your client out, can you frame it in a way of, my client needs this money so they can move? Moving is expensive. If they won't make a payment to your client to move, will they agree to waive their share of the rent until they vacate the unit? Again, to give them that money to get out of the unit. Also talk about rent references or future references from the landlord. If you can get a good or at least a neutral reference as part of the settlement agreement, that can be very important for your client's ability to move somewhere new in the future. And then specifics on how and when your client will surrender the keys to the landlord, because if they don't give up the keys or they don't formally waive their possession of the unit, even if they're not there, they have not technically vacated the apartment. So if that needs to be part of the agreement, talk about that with your client.
Thank you, Sarah. So now we're going to turn to talking about the form of the agreement, or the terms, and specifically about how generally you're going to want to always draft your own agreement. There are form agreements that the court makes available. These agreements are not generally favorable to tenants and have a fairly narrow interpretation of how the obligations and remedies involved in the agreement should work out. Each unique case deserves its own unique settlement agreement, and that's something you can work in with your mentor, and of course talk about with your client so that you make sure that all their goals are being advanced as much as possible. So in drafting your own agreement, the parties are always free to write their own agreements rather than using court forms. It's always a good idea to be the drafter, and part of this is that there's a certain inertia to, if you draft something, it's more likely that the other side will just accept it rather than if you're trying to edit or revise something that someone else drafted. And so there's some momentum there that you can take to your advantage. It's maybe some laziness on the side of some of opposing counsel that you could also use to your advantage. When preparing for mediation, if possible, draft agreement in advance and bring it with you, even if you have blanks to fill in. This will give you time to work through issues in advance, carefully choose your language, and have someone else review it without time pressure. And you can check in with your mentor. And also, this gives you an opportunity, if you have something in writing that's very concrete, just like if you have estimates or other things that are other preparations very concrete, that helps you have a more comprehensive and informed conversation with your client as well about what kind of resolutions work best for them and what they would take, what they would accept, and what maybe they don't want to accept in terms of settling the case. And so going back, and this is something we've talked about a few times about all the different options here, you really want to be creative in terms of negotiation. And it's really important that it's very important for you to have an understanding of the case and the merits and what was foreseeably will happen in the legal process and what will happen at trial. But you're not limited by what legal processes or what are the actual issues, claims, or defenses in the case in terms of how you resolve. So are there pretexts, agendas behind other parties' actions, motivations, ways that you can make the other party happy and make your client happy in a way that maybe is thinking outside the box? Can your client resolve that issue through that kind of thinking outside the box and also get what they want while helping make the landlord happier in some way? Are there remedies that either party desires in which the court cannot order at the end of trial? So for example, we've talked a few times about how difficult it can be for people to move units in many kinds of subsidized housing. Well, if a landlord has a unit that they can move someone to in subsidized housing, that might be something you might be able to get an agreement that you wouldn't get as part of a permanent injunction at trial. Can you create additional opportunities for if your client makes a mistake or has difficulty complying with the settlement? And part of this is really important to think about, like imagining what are the issues potentially for your client and how you could try to address those in the settlement agreement to protect them from bad foreseeable outcomes. What other considerations you want to take into account? And so here's some more ideas. Consider entering a conditional agreement or one that offers two options. And this is really, and I think this is just to give a little bit of context, this is in reference to emergency rental assistance. So as you guys have, I think as we've talked about some in this presentation, there's some emergency rental assistance money from the city that is available for tenants, although it could be very difficult for tenants to get given some of the hoops and issues with the system at the moment. But if a tenant could potentially get this money, emergency rental assistance, which will usually only be given if the agency determines that the money would fit into some larger plan to prevent the evictions. So often if they wouldn't pay the entire amount, a tenant might have to enter into a payment plan or some other kind of way to resolve the issue, which puts some risk on the tenant if the money doesn't go through and they enter a payment plan where they still have to pay the whole amount owed, assuming that it had gone they got the emergency rental assistance. You might want to make conditional. The tenant gets emergency rental assistance by X date or a reasonable payment plan kicks in. So you maybe have two alternative payment plans depending on whether or not emergency rental assistance was paid or not paid. You might also want to build in second and third chances, where if a landlord alleges housekeeping violations, weave in a test period, schedule inspections, and require a tenant to correct identified issues within X days. The landlord will file a motion for judgment. So create, buffers or other kind of opportunities to try to address the issue without further litigation and harming your client. If there's an outstanding transfer request based on reasonable accommodations or safety, include reasonable accommodation provision requiring landlord to cover moving costs if transfer occurs. And so, and again, depending on what your client's goals are, think about other ways you can try to meet those goals, whether or not they could have happened at trial through the settlement agreement.
So some special considerations for tenants specifically that have Section 8 housing choice vouchers. You want to be prepared for settlement as early as possible in these cases because if a client gets a client with a voucher gets a judgment against them, they can lose the voucher. You also want to be ready early because your client can vacate and take the voucher with them, but even more than a normal tenant, they are not fully in control of that process. They have to obtain a transfer voucher. The new unit has to pass inspection. The new landlord and the client must lease up with a program, and that process can take several months. And again, your client is not fully in control of that. And they just might find it difficult to find a new place, especially if they've got a large family and their vouchers for a larger unit, there just might not be a place available. So the sooner you can get started on that process, the better for your client. in terms of finding a new place, there are some resources available to try to help you and your client. The Aging and Disability Resource Center, Bread for the City, and Lift DC, and other social service providers, but you can't count on that. They may be able to help, but they may not. And then for all subsidized tenants, again, the risk of losing your subsidy in an eviction case is very real. So make sure to consider carefully whether the settlement terms can result in a loss or risk to the subsidy. Again, Public Housing and Site-Based Section 8, the subsidy is tied to the unit, so you lose the subsidy if you vacate the unit. But also a judgment or an eviction can also make a client lose a voucher. All programs, if they're evicted based on a drug-related criminal activity, they lose the voucher and they're barred for readmission for 3 years. And then Section 8 housing choice vouchers, judgment or eviction can result in the judgment voucher termination. If it's for a serious lease violation, that termination is mandatory. If you're not sure if your specific case counts, talk to your mentor. And so talk to your mentor and then talk to your client about all of the risks involved with settlement, staying and fighting, or trying to leave.
And I think this maybe is post-settlement proceedings. So turning to, let's say you entered a settlement agreement with the other side, then you're going to be wanting to be thinking about those terms and how those terms and the remedies for violations of those terms might impact your client, right? So as we've been talking about before, often in these cases, the remedy for a landlord, if the tenant, if the landlord claims that the tenant violated the settlement agreement, will be some kind of motion for a judgment, whether that's a redeemable judgment or a non-redeemable judgment. So typically, this is often what we would, as mentors, I think, suggest in almost all instances. There'll be a requirement for the landlord to file a motion. The motion will be scheduled for an evidentiary hearing in landlord-tenant court, and you will remain counsel of record. And depending on the specifics of that case, you may or may not have arguments. You'll hopefully have some arguments for being able to prevent that judgment from being entered. And certainly, if it's a good behavior agreement situation, it might be very similar to like a mini trial where you're basically arguing. You're putting on evidence whether or not that violation of the agreement, that conduct occurred or not, for instance. When the tenant claims a violation of one of the obligations that the landlord has, then again, typical settlement provision will require the tenant or you, as their counsel, to file a motion to show cause or to enforce the agreement. It might require some kind of notice period. Again, it'll depend on the terms of the specific agreement. Again, generally, this is all going to be governed by the terms of the agreement that you drafted, so hopefully you like those terms. And the motion will be set for hearing. And then if you're on the affirmative, like you're trying to get some kind of relief, then you'll be putting on evidence and arguments to support getting like an order requiring repairs, an order requiring some other action by the landlord, and there'll be some kind of resolution, ideally, where the court enters whatever kind of remedy you're seeking, often as some kind of order requiring some kind of equitable relief. And importantly, in all these circumstances, you want to be thinking about how, even if you have a settlement agreement, you could always renegotiate or try to resolve the issue in some kind of way. That might involve amending the agreement, that might involve just finding some way to resolve a specific issue in a way that best advances your client's goals. And that is the last slide. So, do we have questions?
I have a question. Can you talk about, I guess, how a landlord can actually go after after, I guess, if they were, for example, out and how much of a compensation that should be if you can't get a plea for the client?
Sure. So the question was if we could talk about how a landlord could go after a tenant for money after they move out, I think outside of the landlord-tenant process. Let me go or? Oh, okay. So yeah, so I think I'm not a collections expert, but so like already in the landlord-tenant branch, if there's an eviction case for non-payment of rent, there's already that's a mechanism to get money from people, right? Like you pay the money or you get evicted. Now outside of that, the landlord could theoretically let's say if they got a judgment for like a redeemable judgment in a non-payment rent case or through a settlement agreement, breach of a settlement agreement or whatever, they could then take that and they will likely have claim preclusion for that non-payment rent case somewhere else. So they could go over to small claims if they didn't get a money judgment in the landlord-tenant branch and collect there. They could also, if they personally served the tenant and or if the tenant counterclaim for money judgment, they can get a money judgment against the tenant in landlord-tenant branch. So assuming there's a money judgment of some kind, they could garnish wages, assuming that the tenant's income is enough that they can have their wages garnished. They could potentially, if there's any property that you could put a lien on or try to take over in some way, then that's also an action they could take. And so that's going to vary a lot from tenant to tenant, how big of a risk that is, depending on how much money they make and what kind of property they have, and also, their own personal assessment of that risk versus all the other kind of factors involved in the case.
I will say that in DC, the wage garnishment protections are very, very strong for people. And so unless one of our clients, all of whom have a subsidy based on not having a lot of incomes, gets a job that is 40 times the DC minimum wage, they're not going to be garnishable, right? So the most likely outcome that we see in these cases is that the debt is sold to some sort of, debt collection agency that, files some claim later, and it can impact people's credit. I think my advice to clients is usually if you're going to move out and we can't get them to waive all the money, don't tell them where you're going. And, they still, if they hasn't been, if they move out before a judgment is entered, they still have all their defenses. So you can still litigate the case later. It's subject to a 3-year statute of limitations. So it's sort of a wait and see.
Question here?
Sorry if I missed this, but I had a question regarding the settlement agreement. The terms of that agreement, are they just applicable to the back rent, or does that dictate the behavior and also the lease going forward?
So it depends on the terms of the settle. Oh, sorry. The question was, does the terms of settlement agreement just go to back rent, or does it affect the lease or the terms going forward? And so it depends on the terms of the settlement agreement, right? So if you bring a claim, if the landlord brought a claim, then a settlement agreement would often resolve whatever the claim that the landlord would have brought, which would just have to go to rent being owed. But the parties can agree to all kinds of things, right? Which could include a prospective agreement to pay rent on time, or to potentially, as part of an agreement, they could modify the lease or not, depending on whatever they think makes sense to the parties and advances their interests the most. And so I think, broadly speaking, you'll just, when you're crafting and thinking through a settlement agreement and talking with your client about a potential settlement agreement, you also want to be talking about your venture, about all the different ways that the settlement agreement can both impact this case and can also impact other issues, right, that we want to be thinking about, where there could be some kind of effect or preclusion along the lines of what Elena was talking about as well. More questions?
We have one question on the internet that I'm bringing Rebecca in to address that's not about settlement.
Oh, that's great.
Can you read the question?
Sure. Could we talk about situations where a right to return is involved, i.e. when tenants have been moved out of a housing project that has been torn down and gentrified or rebuilt? How can we enforce? What notices are required by the government, etc.? I'm thinking, for example, about what is coming with Berry Farms. Unless, Paul, you want to take it.
No.
All right.
So in the district, there has been a move over the last 20 years or so to tear down public housing and rebuild some sort of mixed income, mixed use housing. And there have been quite a few properties where the buildings, the public housing buildings have been torn down and tenants have languished for years. I was recently quoted in the paper saying, all these properties are stuck, tenants are out there, they haven't lived in their own properties for years, how do they get to come back? And that's what this question is really about, how people come back to those redeveloped properties. And the first piece is that they have to finish building them, which is not happening for Berry Farm, Park Morton, Kenilworth, et cetera, et cetera. So none of the tenants in Berry Farm, Park Morton have any particular rights to return. There is no official right to return in the district. The Housing Authority has said that they will honor the right to return, but there is no legally binding document that requires them to accept these tenants. The Housing Authority is supposed to keep in contact with people. I can tell you from my knowledge in Kenilworth courts, there were 70 some tenants before the properties were torn down, or part of the property was torn down. They only have contact with 41 of them. And so the Housing Authority is losing people, not keeping track of people, even though many of those people have moved into a different Housing Authority property or been given a voucher. So there is no legal right to return, or nothing that's enshrined in any particular legal document that a tenant could enforce.
Thank you.
And if whoever asked this question wants to talk more about it, I'd be happy to have coffee and talk about it for hours.
And for the majority of people on, this is not going to come up in your initial right to counsel case. So that's the end of our right to counsel basic training. For everyone who has stuck with it online, thank you so much for joining in. For those of us in person, it's so nice to have people. This is our first in-person training since, March of 2020, and so it's really nice to be able to be with people. Huge thanks to Kroll for hosting us and fixing all the technology so that it works, and delicious lunch. And, we're really excited about getting to place cases. Our first letters guaranteeing representation have gone out. We've had our first tenants contacting us, asking for lawyers. So as soon as you're ready to take a case, whether it's next week or next month or next year, please do let us know. You're welcome to reach out to me, to Adam, to your mentoring organization, and we will make sure to get you a case to work on. If anyone has any questions, those of us from legal services providers can stick around for a little bit. Folks on the internet can always email us. And we're just really, really so grateful and excited. So thank you so much.